All right, can we bring the defendants out, please? Can you, I don't know what's on that screen, just make sure whoever's on it is off. Thanks. Can you turn the defense screen on in case it's off? Is your screen on? It's right in front of you.
It's showing connecting to network.
Okay.
But it was on earlier. With
Okay.
Zoom, I think.
So how do we work this out?
Good question. One, you can get on the Zoom if you want. It can be on that screen. Two, if both Ms. Wood and Ms. Feely are on, that monitor that currently isn't working, we could put on your desk. It can be on either desk. No objection. Okay. So if you want, is it not working? Okay. But why don't you put it with Mr. Francis? It's heavy, careful. Yeah. Go. Does it reach? So the answer is it doesn't reach. But let's put it there and we'll just get an extension cord. And is that thing still saying Mr. Trepanier connecting?
It's still showing connecting to network.
All right. So we'll get IT to come down here. They can bring in it. Oh, look at him. Thank you, Deputy. Yes, ma'am.
She was on her way here and she started feeling nauseous, so she was stopped at urgent care.
Okay. She should get a note from the doctor and report down here as soon as she gets that note from the doctor. Thank you. So that is showing it's on and working. Okay, my face is okay. I'll get it. I promise I'll get that off the screen. But it is showing the Zoom session. That's not showing the Zoom session. Okay, you restarted it. Okay. I don't understand how it's on there.
We were trying to be the workforce, but I was paid people. I could sing the tune right now. I could sing the tune right now. Somebody, oh, but that was on, I ain't got no money, so I'm gonna she, you know, she. Sorry. No, I didn't know nothing more.
What's it looking like on the screen? So I can't see it. So you shaking your head's not telling me.
So I've been holding the power button for the morning.
Okay. I'll have IT come get it. You can stop messing with it. IT can come fix that one will work through. Ready? Okay. We're going to get on the record now. This is 19 SC 167684, State versus Tolbert and Williams. We picked a jury yesterday and we are hopefully about ready to start with getting the jury in here. There are a couple of matters we need to cover before we can begin, jury related. But before I get to that, Mr. Trepanier, anything from the state that we need to cover before the jurors come in?
I just want to raise a logistical issue. We are working with the technology has been working so far except for one video that we have. So we're just working through that logistical issue for a witness that's a few down the line.
Okay. It's a video everyone has. You're just having a little trouble getting it to
play and share via the system.
Okay. As a technical fallback, it has worked in the past, running a direct line to the big screen, and that direct line is here. So you have that as an option.
And I think what the issue we're running into, Judge, is it's like the proprietary player. And so that's where the holdup is currently.
Okay. Well, that may happen from software from 4 years ago. All right. Ms. Feely, anything from Mr. Williams before we get going? And Mr. Francis?
No.
Good. Okay. We're going to bring juror 21 out so that she can get on the record what her concerns are about her potential conflict. I have an update for you. Juror 6 did leave her home in Roswell and now reports that as she got partway here, she really didn't feel well and has stopped at urgent care. So I have had my staff direct her to get any and all paperwork from urgent care and bring that with her as she comes down here. We're going to talk with juror 21. And after we do that, we will probably have one more outreach to juror 6 to get an ETA. And then we'll need to decide whether we want to wait for that or go forward with one alternate rather than 2 on our very first day of evidence. So just be thinking about that. Can you bring juror 21 out, please? Is that screen working now or not? No?
It's still black, Judge. Yeah.
Hold on one second. Mr. Dorsey, it is the prosecution device that is not communicating. Thank you. Good morning, ma'am. How are you? Good. Appreciate you being here. It was brought to my attention last night when my staff finally contacted you. We kept calling your number and it went straight to voicemail. And then we were told voicemail was full. So that was frustrating. We couldn't get word to you that you had been selected as a juror, but eventually you did call someone on my team and explained that you had a flight to Florida today, which was news to me. That was a surprise. Hold on, I'm gonna give you a chance to talk. But we didn't know that, and not knowing that, you were selected to serve because we weren't aware of any hardship. I learned that you are a student, a rising junior. School is down in Florida, but school wasn't until I thought August that school started up. So why don't you share with us what the situation is so that we can sort through whether that's something we can accommodate, or maybe you've already decided you're here, so you're going to do jury duty. But why don't you tell us all what the situation is?
So yesterday, I raised my part for the hardship, but my dad told me the wrong dates that we were supposed to go at the time.
Okay.
So he told me the right dates. I came back and told her, what's your name? Boy, he told tell you what happened, but my phone was dead to show proof. So I got the dates and stuff.
Okay, so when we talked about how, and you did raise your card, I have a little red H next to your name, but whatever hardship you provided wasn't one, or you changed your mind or whatever, because I promise you, you didn't tell us about a flight to Florida.
Gave me the wrong date, so I was like, okay, so never mind.
Got it. Okay. Well, what is the situation? When are you supposed to go to Florida and for what?
So then it's for, and it's for my niece's birthday,
Okay. When's her birthday?
the 21st.
The 21st. Okay. Who all is going in your household?
Everybody.
All right. What happens if you don't go? Okay. But I mean, it's your family is okay if you, they'll be disappointed, but it's not that you're not allowed to stay alone or anything.
Yeah, but I don't know I don't know what they really would say, because it just sort of comes to the jobs.
Okay. Got it. Mr. Trepanier, do you have any questions for juror 21?
No, Judge.
Okay. Ms. Feely? Mr. Francis? All right. So we're going to talk about it, but I just want to manage your expectations. Chances are we're going to say you need to stay because we didn't know about this. Not your fault. Tell your dad to get better dates next time. But these things happen. But we can't run out of jurors. And you were one who was deemed fair and impartial and a good person to hear the evidence in this case. And it's hard to unwind that decision after it's already been made. So we're going to talk a little bit. And if you come out with everyone else, it means we've decided that we need you to stay on the jury. Okay. Anything else you want to add? No? Okay. Thank you for being here on time. Good. It is connected. Perfect. Thank you. What was the issue? Okay. Well, we tried that a few times. I guess I got to get a finger like yours. Okay. Thank you. All right. Mr. Trepanier, your thoughts about juror 21? Hey, I need you, Mr. Tolbert, it's okay for you two to talk, but you haven't learned your library voice real well. I'm gonna get to you, okay? I'm working my way around the room. Mr. Trepanier, thoughts about juror 21?
I don't think at this point we make any accommodations for a judge.
I agree. It's probably frustrating for her, but these things, as I said, happen. Ms. Feely?
Similar, I would be interested where we are with juror 6, would kind of affect how desperate we need to keep her, but.
Right. Assume we're not seeing juror 6. That's my assumption. We'll make one more phone call, but I needed to hear from juror 21 first.
Keep her around. If we're
Okay.
looking one already.
Right. Mr. Francis?
No objection, Your Honor, I agree, with, co-defendant counsel.
Okay.
Does depend on the other situation.
Got it. Okay. Can you, let me do it this way. Okay, we're gonna try to get one last bit of information from juror 6. While we're waiting on that, Mr. Francis, is there something we should talk about, or you and Mr. Tolbert are
I think we're okay. Are we okay? Mr. Cole?
for right now?
Yes, we're okay. I understand.
We're straight? Okay, good. Ms. Feely, anything we need to work through before we bring the jurors out?
No.
All right. Let's get one last input from juror 6, but unless we hear that she's 10 minutes out, I think we go forward, and she may well show up. She won't be serving as a juror anymore. I'll deal with her on the side and manage that. But I think we need to go forward with 13 unless we hear, like I said, she's on the verge of getting here. Mr. Trepanier, any objection to handling it that way? I'm just anxious to get started. We really need to try to finish this trial if we can this week.
Yes, Judge, and no objections.
Okay. Ms. Feely?
No.
Mr. Francis? Okay. Hey.
Send me these messages.
Yeah.
I'm not getting them.
Oh,
I just hear you saying, so I'm like,
okay. It's weird because you just wrote back.
okay, maybe it's a delay.
Okay.
Okay, you want me to call her?
We need to call one last time to say she still needs to come down here. So but just see what should let her know. Everyone is waiting on her. Should I call her?
I don't know if you can. Okay, we'll figure it out.
So 2 minutes. No. We're stuck right now anyway. Go ahead, give it a question. Thank you.
Roll call order, may I see it?
Ready? Okay, so I spoke with juror 6. She is at an urgent care, she says, in Roswell, and that she is feeling nauseous and has, quote, a stomach ache. I've explained to her that she should get all the documentation following her meeting and come on down here with that, and she and I will have a conversation. I think we need to move forward rather than wait the unknown amount of time for juror 6 to show up, if that even happens. But I'm happy to get input from counsel for the 3 groups here. Mr. Trepanier, your thoughts?
I think moving forward is correct, Your Honor.
Ms. Feely?
That's fine.
And Mr. Francis? So I will excuse juror 6. If she shows up, she will watch, but she'll watch from the gallery and not from the jury box. And then, as I said, I'll deal with her, and we will go forward with 13 jurors. Anything else, Mr. Trepanier, before I bring the jury in?
No, Your Honor.
You're ready with your opening?
Yes, Judge.
All right. Ms. Feely, anything else? Have you and Mr. Francis discussed who will go first, assuming you're both given openings, neither of which you need to do? You just did. All right. Excellent. So it'll be Feely, then Francis. We'll go alphabetically, at least with openings. And if you develop a particular rhythm with cross-examination, let me know. Either side can, I don't want to constantly say Feely first if you want to switch it around. But what I'm going to default to is turn to Ms. Feely first and then Mr. Francis. If I should switch that, let me know. Or if you want me to just every other witness flip it around like we did with jury panels, that's fine too. I don't want you, Mr. Francis, to feel like you're relegated to going last. Okay? All right. Let's bring the jurors in, please. Bless you.
Rise for jurors. Jurors, the president accounted for.
Thank you, Deputy Gordon. You all can be seated. Good morning, ladies and gentlemen. It's good to see your semi-smiling faces back here. Appreciate everyone being on time. We were a little delayed because there's actually supposed to be another member of your group. And that person this morning said, oh, I just didn't think I would come in today. Which isn't how it works. It's not an optional program, as you all understood and have demonstrated. So I'm working through that on the side. There'll be consequences for that individual who may arrive kind of midday, but will not be joining you sitting out there. Don't follow her path the rest of this week because it's not going to be a super happy ending for her. She made you all wait an extra 40 minutes. We've been able to cover a few things that we needed to go over, but we really are unable to move forward unless all of you are here. And that's why the whole on time thing is important. And you nailed it. So thank you for being here and being on time. And I apologize on behalf of the unnamed juror for this late start. I want to talk about a couple logistical aspects of your new role as actual jurors. Then I need to swear you in as jurors, and then I need to give you some basic legal instruction. And then I will be quiet, and the lawyers will start doing what they need to do in this case. First, logistically, from now on, when you come to the courthouse, you do what you did today, which is report to the jury room. Don't come into the courtroom, but go straight to the jury room. That is your private space. And it's necessarily so because it is inappropriate for other folks to mingle with you while you're jurors. Inappropriate may be too strong a word, but when you're walking down the hallway and you're looking which way is the restroom or where's a vending machine, if you were to see Mr. Trepanier or Ms. Feely or Mr. Francis or any of the lawyers and try to ask them a question, they may well recoil. And it's not because they think you've got something they don't want, but it's because it's very important that the lawyers not interact with you outside the four walls of the courtroom so that all the other lawyers can see what was said, hear what was said, and have a chance to be involved as well. Something you're going to hear me say more than you want is that it's important that you do no outside research, that the evidence you get in this case come only from witnesses who testify and exhibits that are admitted during trial. So that has as a corollary, you don't go online and research something. But it also would mean you don't have a casual conversation with one of the lawyers. So don't view them as being socially awkward. They're nice enough people. But when they see you in the hallway, if they do, they're going to act like they just ran into someone famous and they're going to kind of scurry away. They're not to be interacting with you all. If you've got questions about when is the next break or where's a good place to eat, Deputy Gordon, his colleagues, my staff, interact with them. That type of interaction is fine because they're court personnel. They're not advocates for one side or the other. As I mentioned before, we can't start till you're all here. That means first thing in the morning. That means when we take our lunch break and you're free to eat as a group. You can eat individually, however you choose to divide up, but we can't start till you're all back. So if one of you says, hey, I'm going to go to that great restaurant spot I enjoy in Clayton County, you're not going to be back in time, and we'll all be waiting for that one juror. So be mindful of the time and make sure you're doing your best to be back in the jury room or here in court, meaning in the building, when we're starting. We will stop as close to 5 as we can each day. I say as close to because there's not a whistle that goes off at 5 o'clock and we abruptly interrupt what's going on. We'll be in the middle of some witness testifying around 5 o'clock today. And as we approach 5, I'll ask whatever lawyer is currently examining that witness, hey, it's about 10 minutes to 5. How much more do you have before we could wrap up? And if the lawyer says we could do it in about 15 or 16 minutes, and that lawyer has been credible in his or her time estimates, because you'll learn about whether you want to invest in lawyer time estimates during this trial. But if we think that that's a realistic time estimate, we'll probably let that witness finish, because that's a natural break point. And so it may mean we stop at 5:10 instead of 5 o'clock, unless one of you tells me I have to leave at 5 each day because of childcare or dog care or whatever it is. But hopefully there's a little flexibility. That doesn't mean we'll go to 6. If we're a little bit before 5 and the lawyer says, hey, I just need 1 more hour for this witness, I'll say, great, we'll come to a natural stopping point around 5, and the remainder of that hour will start at 9 o'clock the next day. So 9 to 5-ish. We take at least 1 break in the morning and 1 break in the afternoon, and we have a lunch break. The lunch break won't be like what you had yesterday if you were in group 2 or 3. It'll be about an hour, and the start time is usually driven by when I have Zoom meetings with other judges or things I have to do, and that may mean we have lunch at 12:30 or 1 o'clock, whenever it is. We will also break whenever you need to. So if any one of you finds that you're just getting a little fuzzy, you need a restroom break, or I just look, if I could walk up and down that hall for a couple times, I'll be able to focus again. Just raise your hand. Let Deputy Gordon know, let me know, and we'll stop. There is no rewind button in this trial. So if you feel like you are losing focus on what a witness is saying, then we probably should pause. You will not get a transcript of witness testimony. I'm going to talk about note-taking in a minute. But it's important that you stay as focused as you can be. If that means we take an unscheduled break, we'll do just that. All right, logistics are done. If you could all please stand and raise your right hand. Do you swear or affirm that you shall fairly try this case between the state of Georgia and DeAnthony Tolbert and Ramel Williams, who are charged with murder, felony murder, aggravated assault, armed robbery, and firearms offenses, and base your verdict solely on the evidence? Please say yes if you so swear or affirm.
Yes.
Does anyone not so swear or affirm? Thank you. You are now officially jurors. Yesterday, you were potential jurors. You've graduated again, 2 graduations in 2 days. One other housekeeping thing, and then this. You are currently in the seat you chose as you walked in, and it was somewhat random. Those of you who came out earlier were further down in the jury box. Please don't take ownership of a particular seat. I encourage you to sit in a different seat, if not every time you come out, maybe at least each day, refresh. Those of you who are sitting closer to me are going to get a closer view of the witnesses' faces. Now, they'll be up on the big screen as well, because I'll shift the cameras. But you literally get a different perspective on the trial based on where you are seated. And so don't always stay way over in the corner, unless that's your comfort zone. I want you to be in as happy a space as you can. But I do encourage you to sit in a different row and in a different column as you come back and forth into the courtroom, with the exception, as I mentioned yesterday, if you're someone who may need to stand up every once in a while because of a hip or a knee or a back, you get a claim to the seats that are at the far right of the jury box is the way you're seated, because you can stand up and that doesn't disrupt anything. All right. Let me tell you a little bit about what to expect from a trial. I don't know that any of you have been jurors before. We had very few people who had been on jury duty before, except if you were in, I think it was the last group, the guy who was a mailman who claimed he'd been a juror 20 times. I've never heard that before, but that was his story. He didn't get selected. But what you know about trials is what you've seen on TV. And unless you were actually watching a trial on TV, like through court TV, you don't know what a trial is like, because it is not what you see on primetime TV. This is the real world, and it's important that you have a good understanding of what to expect. First, note-taking. You all have notepads, and you are free to take notes. You are free to jot down whatever you want throughout the trial. Note-taking is not required, but as I mentioned already, you will not be getting a transcript of witness testimony. So if someone says something that to you seems particularly noteworthy and you want to write it down, feel free to do that. But I won't be saying, hey, I noticed you didn't pick up your notepad at all today. It is purely voluntary. It's meant to be an aid for your recollection as you go back to deliberate at the end of the trial. It's important if you are a note taker that you not let it become all consuming. One of the things you'll be doing is deciding the credibility or believability of the witnesses. And humans do that in lots of different ways. Sometimes you can just tell the person says the sky is red, like the person is either colorblind or they're not particularly credible. But sometimes it's more subtle, and you might notice the way a witness physically reacts to questions. Maybe when one side is asking questions of the witness, he's very engaged and is looking at you and leaning forward. And then when the questions get a little more difficult and confrontational from the other side, the witness looks away and has completely different body language. That may say something to you about that witness's credibility. You will miss all that if you're buried in your notes trying to write down every word a witness says. You can't do that. It's not physically possible. The only person in this room who has the skill set and the finger dexterity to take down everything that's said is Ms. Rivers. And that's what she's doing right now. Unfortunately for you, you don't get her transcript. Her takedown doesn't become a transcript until several months down the road. So use notes as you see fit. Your notes will be private, as in you don't share them with anyone else in your group until you begin your deliberations. When you're deliberating, you're free to say, hey, I wrote this down, look at this, whatnot. Then they'll be destroyed. You don't need to worry about your notes making it onto a blog somewhere. I don't review them. If you draw a funny picture, the judge has a big nose, I will never see that. It will get shredded. When the trial is over, the notes are literally shredded. Some of you may have notepads from a previous trial. You notice there are pages missing in there because we shred the notes from the previous trial. The defendants, Mr. Tolbert and Mr. Williams, are charged with various crimes, which are violations or alleged violations of the laws of Georgia. I'm going to read to you right now what is alleged in this indictment. You'll get this document during your deliberation. So some of it is kind of legalistic because the state has to charge things in a certain way. Don't panic if the wording is a little awkward. This document will be with you during your deliberations. And a reminder before I dive into this, these are allegations. These are proof of nothing. And Mr. Williams and Mr. Tolbert sit before you with the presumption of innocence in their favor. There are 10 counts in the indictment. Count 1 alleges that both defendants committed the offense of murder. And the specific allegation is that the two here in Fulton County on the 14th of January, 2019, did unlawfully and with malice aforethought cause the death of Frank Fluitt, a human being, by shooting him with a handgun. Count 2 charges both defendants with felony murder. And there's several counts of felony murder, and you'll understand why as I read them, and more particularly at the end of the trial when you learn about the elements of felony murder. But count 2 is felony murder, and the allegation is that the two defendants here in Fulton on that same day, January 14, 2019, did unlawfully during the commission of a felony, that felony being armed robbery, cause the death of Frank Fluitt, a human being, by shooting him with a handgun. Count 3 charges both defendants with another count of felony murder. The allegation is that here in Fulton on that same day, the defendants did unlawfully during the commission of a different felony, that felony being aggravated assault. They caused the death of Frank Fluitt, a human being, by shooting him with a handgun. Count 4 is brought against Mr. Williams only. And the allegation, it's another felony murder count. The allegation is that here in Fulton on the 14th of January, 2019, Mr. Williams did unlawfully during the commission of a felony, this felony being possession of a firearm by a convicted felon, which is count 9, that he did cause the death of Frank Fluitt, a human being, by shooting him with a handgun. Count 5 charges only Mr. Williams with the final count of felony murder. The allegation is that Mr. Williams in Fulton on the 14th of January, 2019, did unlawfully during the commission of a felony, this being a different count of possession of a firearm by a convicted felon. It's count 10 of the indictment. He did cause the death of Frank Fluitt, a human being, by shooting him with a handgun. Count 6 charges both defendants with armed robbery. The allegation is that Tolbert and Williams on the 14th of January, 2019, here in Fulton, did unlawfully, with the intent to commit theft, take the property of Frank Fluitt, specifically a backpack, from the person and immediate presence of Frank Fluitt by use of a handgun, an offensive weapon. Count 7 charges both defendants with aggravated assault. The allegation is that here in Fulton, on that same day, the two defendants did unlawfully commit an assault upon the person of Frank Fluitt by shooting him with a handgun, that handgun being a deadly weapon. Count 8 charges both defendants with the offense of possession of a firearm during the commission of a felony. And the allegation is that here in Fulton on that same day, the defendants did unlawfully have on and within arm's reach of their person a firearm during the commission of at least one of the following felonies against and involving the person of Frank Fluitt: murder, felony murder, armed robbery, and aggravated assault. Count 9, the second to last count, is against Mr. Williams only. And the allegation is that here in Fulton County on the 14th of January, 2019, Mr. Williams did knowingly and without lawful authority possess a firearm, specifically a handgun. The accused, Mr. Williams, having been convicted of a felony on case number 09CR1423302 from the Circuit Court of Cook County, Illinois, on April 9th of 2010. And then count 10, the final count of the indictment, charges Mr. Williams with another count of possession of firearm by a convicted felon. The allegation is that on that day we've been talking about in Fulton County, Mr. Williams did have on and within arm's reach of his person a handgun during the commission of a felony against and involving the person of another. The accused, Mr. Williams, having been previously convicted of a felony involving the possession of a firearm in case number 14 CR 2198801 in the Circuit Court of Cook County, Illinois, in June of 2016. Ladies and gentlemen, these charges are not evidence of guilt, and you should not consider them as evidence or even an implication of guilt of any crime whatsoever. The defendants sit before you with the presumption of innocence in their favor, and the presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that one or the other or both defendants is guilty of one or more of the crimes charged. A defendant should not be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt, rests with the state throughout the trial. It never shifts to the defendant. That doesn't mean, however, that the state is required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. The state's burden is to prove the defendant's guilt beyond a reasonable doubt. And that term means just what it says. It is a doubt based upon common sense and reason. It doesn't mean a vague, arbitrary, or speculative doubt. It's a doubt for which a reason can be given, a reason that arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. The defendants, who are presumed innocent, have no burden of proof whatsoever. If, after giving careful consideration to the evidence in this case, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if no reasonable doubt exists in your mind about the defendant's guilt, you would be authorized to convict. So the basic structure of a criminal trial like this one is that in just a few moments, both sides will have the opportunity to make what we call opening statements. That's when the lawyers give you a preview of what they think you will hear or won't hear during the trial. It's sort of a forecast. The witnesses are going to come in and they're going to say this. They won't say this. You'll see this kind of evidence. You won't see this kind of evidence. It's important for you to remember throughout the trial that nothing the lawyers say is evidence. Evidence comes in two forms. It's what a witness says once she's been sworn in, and then it's an exhibit, a document or a piece of clothing, a physical exhibit. That's evidence. A lawyer telling you that a witness is going to say X is a forecast, but it's not evidence. The witness needs to come in and actually say X. You will likely hear 3 opening statements. You will for sure hear one. You'll hear one from the state. Because the defendants have no burden, it may be that Ms. Feely, and now you can meet Ms. Wood. I mentioned Ms. Wood yesterday. She was busy doing something else. That's another lawyer for Mr. Williams. But Ms. Feely, Ms. Wood, and Mr. Francis may not say another word in this trial. I bet they will, but they don't have a burden to prove anything. My guess is they'll give opening statements. They're not required to, but they may want to give you a sense of what they think the evidence is going to show, or more likely what it won't show. When those openings are done, I will turn to Mr. Trepanier and say, call your first witness. That person will come on in. Deputy Gordon will swear that person in, and that person will answer her first question. That answer is the first evidence that you receive. After all the evidence has been presented, and we'll know it's done because I'll ask Mr. Trepanier, call your next witness. And at some point later in the week, he'll say, Judge, the state rests. That means they're not presenting any more evidence. Their case is closed. Then I turn to the defense, because the defendants have an absolute right to present evidence if they want to, but no obligation to do so. I'll turn to Ms. Feely, and at some point she'll say, Mr. Williams rests. And I'll turn to Mr. Francis, and at some point he'll say, Mr. Tolbert rests. Then we're done. We're done with all the evidence, and the lawyers get one more chance to address you all as a group. That's when they present their closing arguments or summations. That's an opportunity for them to attempt to persuade you, to argue with you about what the evidence has shown or failed to show. There'll probably be PowerPoints. They're going to tell you a little bit about what they think the law is in this case, and they're going to try to convince you to find the defendant guilty, if it's the prosecutor, find the defendant not guilty, if it is Ms. Feely or Mr. Francis. But again, what those lawyers tell you is not evidence. So if they're up there arguing real persuasively, and you heard this witness say that, and that's not what you remember the witness having said, you're going to need to resolve that conflict when you're back in the jury room. But it's the witness's statement and not the lawyer's statement that controls. When those lawyers are done with their closings, I will give you the more formal legal charge that you will then take back with you into the jury room. That's when I tell you the elements of murder, of felony murder, of aggravated assault, etc. That's the law that you must apply to the facts as you find them to be. You'll get that charge, you'll get a verdict form, and then you begin your deliberations. Now, during the trial, along with calling witnesses and presenting evidence, the lawyers have the opportunity to object if they think that a particular question may be eliciting evidence that's improper, or maybe something's happened and the lawyers want to have that stop. That you see on TV, a lawyer stands up, objection, this whole court's out of order. You won't hear anyone say that, but they may say objection, hearsay, objection, leading, whatever it is. Perfectly appropriate for lawyers to do that. My job when I hear something like that is to rule on the objection. And I'll either say sustained, in which case whoever had asked a question needs to ask a different one, or overruled. If it's overruled, we keep on going in the way we were going. Nothing I say in ruling on those objections should be taken by you as some sentiment that I have about who's doing a good job with the lawyering, or whether that was particularly good evidence or bad evidence. Evidence isn't good or bad. It's probative or it's not probative. I need to rule on those objections, and in doing so, I'll be saying some words. If I sustain the objection, it may be that the lawyer who made the objection says, Judge, I move to strike. You've sustained my objection. I want you to strike that testimony. Maybe a witness said, well, I was walking down the street. This guy came up to me and he told me X. When a witness is recounting what he or she heard, you may get an objection to hearsay, because sometimes it's hearsay for a witness to say, this is what someone else told me. We generally try to get the teller as opposed to the listener to be testifying. And it could be that the lawyer who objected to the hearsay didn't figure out that it was hearsay until the witness said, well, that's when the guy told me that it had been really rainy that night. Objection, hearsay, sustained. Judge moved to strike. If I strike it, I will tell you specifically what is stricken. You all need to disregard what that witness just said about whether it was raining last night. If I say that, I'm not saying it just as an exercise. If you wrote it down, you need to cross it out. If you're back there deliberating and someone in your group says, hey, remember that guy who said someone told him it was raining that night? That's how we know it was raining. You need to police that and say, nope, that evidence isn't before us. We can't weigh that when we're deciding, has the state proven its case? That may seem like an unfair exercise. How do you unknow something you know? I want to reassure you that if it is central evidence to the case and it comes in and it shouldn't have, we get what's called a motion rather than an objection. I want to talk about motions. Sometimes a lawyer will stand up and say, Judge, I've got a motion, which is often shorthand for you get an extra break, because a motion is something where the lawyers need to speak pretty freely about what their concern is. They may have a forecast about what's about to come out and they don't want it to come out, and they have a legal argument as to why it should not come out. They can't talk about that in front of you because they have to say, here's what this witness is about to say. And if there's a legal reason why that witness shouldn't be able to say it, we need to discuss that outside your presence. So you may get some extra breaks if there is a motion. I'll often, if I have a pretty good sense of what the motion is about, say, could we hold that until a natural break so that we're doing work while you're taking a break rather than creating an extra break. But as I was saying, if what a witness said that shouldn't have come out came out is really, really important, we'll have a motion and handle it a different way. And you ought not to be put in the dilemma of having to unremember something that is central to what you need to decide in this case. As with objections, anything I say in ruling on a motion is simply a legal ruling. It's not a comment on the strengths or weaknesses of any particular side's case. You all have a role as well. I've talked about what the lawyers do and what I do. You all are the fact finders. You decide whether any crimes were committed in this case. Were these two gentlemen even at the scene of the crime? You're going to be deciding that. What happened at the scene of the crime if they were there? You are the fact finders. You have to apply the law I give you, but you decide what the facts are in this case. In other words, what the state has proven beyond a reasonable doubt and what the state has not. In doing so, you will necessarily be deciding the credibility or believability of the witnesses who appear before you. And in deciding credibility, you're free to consider everything you've already heard about the case, including what other witnesses have already said, as well as the manner in which the witness testifies, that's you watching the witness testify, and the witness's interest or lack of interest in the outcome of the case. Now, you as fact finders may from time to time have questions. 99% of the questions are going to come from the lawyers. They ask witnesses questions. But during that back and forth, you may have a question that doesn't get answered by the exchange between lawyers and witness. You can address that by writing your questions down on those note cards. You'll see on the little shelf in front of a few of the jurors, there's some 3x5 note cards. Please share those amongst yourselves. When we're done with every witness, meaning all the lawyers have had a chance to ask those witnesses questions, I will turn to you all and say, do any of you have questions? And if you do, don't stand up and ask the question, but write it down on the card. And Deputy Gordon will collect all those note cards. I will review them with the lawyers, because just as a lawyer can ask a question that is objectionable, jurors can as well. So it may be you have the question that you think is the greatest question ever, but it's one that the lawyers would love to ask as well. It's just not a legally proper question. I won't ask that. I'm not going to tell you, hey, juror 6, that was a bad question. In fact, no one knows which your questions were. You don't put your name on it. You just write the question. Was it dark that night? Maybe that's real important. And the lawyers forgot to ask. Oh, yeah, it was really dark. So visibility was limited. If they don't explore that adequately and you've got a question about visibility, you write it on a note card. I will ask the question of the witness. When I'm done asking your questions of the witness, the lawyers will have a chance to follow up, because inevitably during the trial, you all come up with a question they hadn't thought of that they're real interested in. And you'll notice, hey, the next 3 witnesses, they asked my question of that witness. It was a good question. Lawyers aren't perfect. There's something they may not pick up on that you are interested in learning about. The way you scratch that itch is by writing the question on the card. The way you never scratch that itch is by doing outside research. If a witness uses a complicated term, and we may have some expert witnesses testifying and they use a word you don't understand, What did you mean by cardiac thrombosis? They should explain that, and a lawyer should get them to explain that. But if that's a term that's used and you don't know what it means, now I'm going to ask because I don't know what that means. But if it's not explained to you, you write it down. Don't go online to look it up because you're getting information outside the courtroom. It may be inaccurate information, but more importantly, the lawyers don't have a chance to explore it with you because maybe if you look up cardiac thrombosis, there are 3 definitions and they're different definitions. And one of them, if that's the one you run with, gives you a very wrong impression about what happened in this case. We would want the witness to explain what she meant by using that term. So please, questions on cards, not to Google or Chat GPT. Last thing about questions. Questions are not evidence. So if you wrote a question and it didn't get asked, you shouldn't draw an inference from that, like, oh, I may be onto something. It just means it wasn't a legally appropriate question. You may receive during the course of this trial evidence that Mr. Williams has been convicted of crimes that are not part of this case. In other words, not the allegations here. That evidence, if any, is being admitted solely to show, if it does, Mr. Williams' status as a convicted felon and for no other purpose. You may not use evidence of Mr. Williams' status as a convicted felon, if there is evidence of that, as proof that he is somehow responsible for the crimes in this case. The fact that Mr. Williams may have committed some other act is not sufficient proof that he committed the crimes charged in this case. Mr. Williams and Mr. Tolbert are on trial for the crimes charged in this indictment and these crimes alone. Similarly, if you receive information about Mr. Williams' status as a convicted felon, you may not use that in any way against Mr. Tolbert. It's not about Mr. Tolbert. It is, if it's about anyone, about Mr. Williams. It's important that you pay close attention to the evidence as it's being presented. As I mentioned, no rewind button. You don't get a transcript of the testimony. So if you start to fade, let me know and we will take a break and let you refresh. It's also important that you view the evidence with an open mind and resist the temptation to say, I figured this one out after the first witness. The state may well call a compelling witness up front, and you may say, we know what happened in this case. But guess what? You haven't heard the defense side of the case if they're going to present anything. And you've only heard from one witness. And you haven't heard what the law is that applies to the case. So keep your mind open until you get into deliberations. And keep your mind open then, but that's when you decide the case, when you discuss it amongst all of you and you consider each juror's views. Each of you is going to bring an angle to this that someone else hadn't thought of. And that's when you start to coalesce around whatever you think the appropriate verdict is in this case, if you're able to unanimously agree on a verdict. Until you begin your deliberations, it's important that you not discuss the case with anyone, to include your group. So when you go to lunch today and you want to make small talk, make it about something other than this case. Don't say, could you believe what that witness said? That was totally unbelievable. You may have a totally different view 3 witnesses in, as that third witness corroborates everything the witness you decided you didn't want to believe had to say. Deliberations need to start only after you've heard all the evidence and you've received the law. It's tempting to want to get a head start on that. Don't. You can talk about anything else you want. That's a pretty broad universe, but don't talk about the case. It is equally important that when you get home tonight and tomorrow night, you limit the way in which you discuss your service as a juror with people in your household, your friends online, whatever it is, and however it is you interact with other people. Well-meaning individuals are going to want to tell you how you need to be a juror. Maybe they've been a juror before. Maybe they've had a situation in their life that they think is similar to this. Actually, they shouldn't learn about what this situation is because you're not going to talk about the specifics. It's okay to say I have jury duty, but don't even get into it's a criminal case versus a civil case, because your well-meaning, very talkative friend is going to say, let me tell you, when the lawyer says this, this is what's really happening. Oh, if a judge overrules, they're hiding something. That's not this case. They simply don't know. They're not in this courtroom. So when the trial is over, and you've completed your service. You are free to interact with anyone, create your own blog, write a song about your jury duty, paint a picture, whatever you want to do. But before then, you need to live in a little bit of a bubble. I don't believe there's going to be media coverage of this case, but if for whatever reason you're driving home and on the radio station of your choice, the person says, hey, the latest update on the Williams and Tolbert case, change the station. I don't think that's going to happen, but you need to not give anyone the latest update on the Williams and Tolbert case, because folks are going to then start giving you their opinion. And that's getting information outside the four walls of this courtroom. And that is the big no-no for jurors, is that outside research, even if it is unintentional, that people are pushing it on you. Ladies and gentlemen, that concludes my preliminary instructions. I appreciate you indulging me, but I needed to cover those things with you. I am going to close my binder and turn to Mr. Trepanier to ask him if he is ready with his opening statement.
Yes, Your Honor.
Great. I want to make sure our screens are working. The big screen down low, is that showing the PowerPoint? Yes, and the big screen up high? Excellent. The big screen down low, do we need to angle a little bit? Can most folks see it? It's good? Okay, great. Thank you.
Good morning, members of the jury. Once again, my name is Brian Trepanier. I represent the state of Georgia along with my co-counsel, Mr. Vincent Fawcett. This is the state of Georgia versus Ramel Williams and D'Anthony Tolbert. And before I begin, I do want to thank you for your jury service and what you are participating in now and will continue to participate in this week. Because without your service, this system doesn't work. And so the state of Georgia just asks that you follow everything that the judge has instructed you on. And you participate in this case as a fair and impartial juror, like we asked you about during jury selection. So what is this case about? Predators and prey. Predators and prey. This case is about our victim, Frank Fluid III, walking down Donnelly Hollowell Parkway at about 3:30 in the morning. I expect the evidence will show that at that time, he will have had a big black backpack on. He then will kind of turn Donnelly Hollowell on the North Side Drive northwest. And in doing so, you will again see him on a different video camera. Now, this camera is not as high quality, but I expect that you will see that. And you'll once again sort of be able to see a black backpack on Frank Fluid III. And as he proceeds down the street, there'll be a combination of video. But what you'll see is that on the Donnelly Hollowell and Northside Drive intersection, a vehicle, Chevy Tracker, gray, with a big wheel on the back. And after Mr. Fluid walks down Northside Drive northwest, that tracker is coming up Northside Drive at Donnelly Hollowell, makes a U-turn, heads back. Heads back. Following now the path that Mr. Fluid is walking to victim in this case. And as that vehicle goes, Mr. Fluid is walking, and he ends up behind a utility pole on the video. So this is not a case where the video of the incident is clear, that you can see everything that happened exactly. But luckily, there will be some witnesses in this case who do indicate and did see some of the activity. What I expect is that you will see Mr. Fluid III walk behind this utility pole. You won't see him come out on the other side. You will also see this Chevy Tracker, while he's behind there, pull into a little driveway area and turn around a little bit. Take a second, and then turn back right back out into Northside Drive again. and stop behind that utility pole, exactly where Mr. Frank Fluid III is. This occurred on January 14th of 2019, approximately 3:30 in the morning. It's dark out. He's walking alone, Mr. Fluid is. And this vehicle makes a U-turn and follows him. What I anticipate is that you will hear from a couple witnesses who were in that area. The first is Miss Sharita Thomas. Now, Miss Thomas has had what seems like a hard couple of years since 2019. She may not remember the exact details, but what I do anticipate her saying is that she was out there. She was working for Allied Universal Security. She saw a car circle. It was weird. Didn't see me. And it was a gray four-door, like our Chevy Tracker. I also anticipate that you're going to hear from Brian Wiley. And what Brian Wiley would say is that he was on his way to work. He was headed north on Northside Drive Northwest towards that Donnelly Howell intersection. And as he's driving, he sees two people tussling. I anticipate that what he is going to say is that as he sees these two people tussling, one of them, his initial impression is that it may be a woman because there's long hair. And what you see in this case is Mr. Frank Fluid III address the long hair. And that there's a second individual tussling. They're tussling over something. What it is, he's not able to state for certain, but they're tussling. And Mr. Wiley, I anticipate, will say, he sees this, and he goes and he kind of makes a U-turn to see what's going on. And he's making that U-turn, he hears a shot. Here's a shot, and as he's turning, he sees someone at the back bumper of that gray Chevy Tracker waving him on. And bent over, just like, get out of here, waving him on. So he drives a little bit more, U-turns again, and then heads back in the direction he was originally traveling, and gets to the intersection of Donald Lee Hallowell and Northside Drive. And when he's there, he slows down, and that Chevy Tracker, again, that pulled out behind him, and passes him in the intersection. And he looks over, and he sees that there are two people in that vehicle. Two people in that vehicle. So, as that's occurring, after that, Mr. Wiley comes back around, and a third vehicle, a 911 caller, makes a phone call. You're going to hear that 911 call, and what I expect that you will hear on that 911 call is that someone else stopped their vehicle, seeing this victim in the road. They didn't know exactly what happened, but they decided to reach out to 911. And so they're on the phone and they ask Mr. Fluid, what happened? What's going on? What they relay is they shot me. They shot me. Not he shot me. Not she shot me. They shot me. The people, vehicle, who had stalked him, saw him, stalked him. What I also anticipate is that when law enforcement arrives on the scene, Mr. Fluid is laying on the ground there, bleeding, sustaining a gunshot wound to the leg. And ultimately, as you're aware, based on the charges, he dies. So obviously an investigation begins. Scene is sealed off, it's secured, crime scene tape is put up. They look for physical evidence. And what you will hear is missing is that black backpack. That black backpack is not with Mr. Fluid when the police arrive. It's not at the hospital where he's transported to. It's not there. I also anticipate that you will see a damaged earring laying on the ground. In some of the photos, I anticipate you may see the actual physical earring itself. That earring matches the one that is in Mr. Franklin's other ear. Signs of a tussle, signs of a robbery. So obviously law enforcement gets an idea of what this vehicle looks like. And what they do is they contact both Georgia Tech, who has a Georgia Tech camera in the area that I mentioned, which catches Northside Drive Northwest, that's blocked by the pole where the incident occurs, and what's called VIC camera footage. Now that VIC camera footage is at Donnelly Hollow Drive and Northside Drive, Donnelly Hollow Parkway and Northside Drive, and those VIC cameras in some places also have license plates. And what the evidence will show is that Chevy Tracker goes up, comes back around, and hits on the license plate reader at that intersection. And that vehicle comes back registered to an Alicia Laflour. The state intends to call Ms. Laflour as a witness in this case. Ms. Laflour is Mr. Ramel Williams' new girlfriend. She was pregnant with his child, and they lived together at 874 Centerville Ave. And so they have a license plate for a vehicle. And what they do is they conduct a traffic stop. Conduct a traffic stop on the vehicle, and in that vehicle are Ms. Laflour, Mr. Williams, and Mr. Williams' sister, Vanessa. And so, in trying to figure out what happened, I expect that you will hear Ms. Laflour testify that she said, you know, where I live with Ramel. I also live with, you know, we have a roommate. That roommate's name is Dan. And I expect that you will hear that the people that had access to the keys in that home were Ms. Alicia Laflour, Mr. Ramel Williams, and Mr. Anthony Ford. The only three people that.
Hold on, Jason. They don't say that on that.
Stop. So hold on. Why don't you chat with Mr. Tolbert for a second? Well, I'll tell. Mr. Tolbert, stop. So, Mr. Tolbert, here's how this works. We can in just a second, but it's important that you talk with your lawyer first before we have a conversation, okay? Why don't you write something down so that Mr. Francis knows what your concern is, okay? All right. Can we keep going?
Yes, sir.
Okay.
The state anticipates that the testimony will be that the people that had access to that vehicle were Alicia Laflour, Ramel Williams, and the Anthony, because they lived in that house. And the investigator in this case, Detective Summer Ben, speaks with Ms. Laflour and gets Ms. Lafleur's cell phone number. She also speaks with Mr. Ramel Williams and gets Mr. Williams' cell phone number. And in doing so, one of the first things that she does, she also talks to Mr. Williams and says, who was driving the vehicle at that time? And what I anticipate you will hear Detective Benton say is that Mr. Williams said, well, nobody was, we were asleep. Maybe somebody, hot wired. And Detective Benton challenges him on that. And I expect that you will hear Detective Benton found that answer odd, because the evidence will show that when the traffic stop occurred later on January 14th, 2019, that vehicle had not been tampered with in any way. Now, with cell phones, you may be aware that cell phone data can place you at a location. So in this case, Detective Benton got the cell phone numbers of Mr. Williams and Ms. Laflour, and was able to determine that Ms. Lafleur's cell phone didn't move from the location that they lived. But I anticipate that you will hear that the cell phone number associated with Mr. Williams, the number, shows activity around or near the crime scene at the time this incident occurred. So we have the LPR reads, and now we anticipate that you will see the cell phones. In addition, Detective Benton was able to obtain a number for D'Anthony Tolbert. And D'Anthony Tolbert's number also shows activity in the same area at this time that this incident was supposed to have been. There'll be a few other pieces of physical evidence that I think are important and that I want to highlight and that I anticipate you'll see. In the photographs, you'll see several shell casings on the scene, 2 shell casings and 1 live bullet. So effectively an unfired bullet. And what I anticipate the testimony will be is that 1, all of those are .45 caliber. That the 2 cartridge cases were fired from the same weapon. And that 3, a projectile that's located in Mr. Fluid is also a .45 caliber projectile. The significance of the live round, I anticipate the evidence will show, is that as a semi-automatic handguns, when they're used, when you fire, a shell casing is ejected. But what I anticipate you hear from one of the Georgia Bureau of Investigation firearms analysts is that if you have a jam or something happens with your weapon, in order to clear that jam, a live bullet has to be used. So I expect the evidence will show that this is not just a single mistake. So the evidence will show that this was an active preying upon of Mr. Frankfurt. You've already heard the process, so I'm not going to belabor this point, but right now we're in opening statements. You'll hear testimony, you'll see evidence, you'll hear closing arguments, and you'll deliberate. And I want to highlight an important concept. And the judge will instruct you on the law at the end. And so I'm not going to dig into the legalese or anything like that right now. But what I want to highlight is parties to a crime and conspiracy. That in this case, there are 2 people acting together. And then each one, based on their actions and what they did, is culpable for the other because they participated in this together. They participated in the shooting of Mr. Frankfurt III, in the armed robbery, the aggravated assault, the possessing of the firearm, the following him. Predators and prey. And so at the end of this trial, the state will ask that you return a verdict of guilty on all counts against both Mr. Williams and Mr. Tolbert. Because as I said, what I expect the evidence to be, especially in light of that 911 call, is that they shot.
Thank you, Mr. Trepanier. Ms. Feely?
So here's the rest of the story. You heard it yesterday. It's long list of witnesses read out to you. It's the state's witnesses. They use the term because almost no one on that list witnessed anything on the night of January 14th, 2019. No one was there except for the one security guard and Brian Wiley. Not a single person on that list will tell you that they saw Raymond Williams at the scene that night. Not one of them. So you're going to hear from patrol officers, detectives, crime scene, fingerprint, medical examiner. A lot of witnesses, and certainly pay attention, but do not lose sight of the fact that these witnesses do not know who did it. You're going to hear that Mr. Wiley was shown a 6-person lineup that contained Mr. Williams' image. Mr. Wiley be one eyewitness. You're going to hear that Mr. Wiley not only didn't pick out Raymond, he picked another person, another picture. But that's the whole state's case. The cell phone records that allegedly put Mr. Williams' phone at the scene. And the camera that allegedly shows the vehicle that's associated with Mr. Williams' girlfriend. You heard that Mr. Williams was then in the car with 2 other people who were not charged. Soon after this happened, the car is processed, you will hear from crime scene people. And you will hear that the detective speaks with Raymond and the other 2 occupants of the car, then releases them. And he goes about living his life. You're going to hear that he was later arrested in Chicago. But that's their whole case. You can determine whether there's any evidentiary value in that. So let's talk about what you are not going to see or hear. No eyewitness identification putting Mr. Williams at the scene. Not from Brian Wiley, and not from the deceased. You're going to hear that he was shot in the leg and he was alert and conscious and made a statement vague. Not from Mel, not somebody I know as X nickname or any identifying information, but he was alert and talking for some period of time. You're not going to have any DNA type evidence that ties Mr. Williams to this crime scene. In fact, one of the live cartridges that was mentioned is tested for DNA. And the GBI witness is going to tell you that that DNA on that live cartridge from the scene could not have been contributed by Williams. It rules them out. You're not going to have blood evidence, you're not going to have fingerprint evidence, you're not going to have surveillance videos of what actually happened here. You don't have motive. You heard about the backpack. You're not going to have the backpack. Where is the backpack? Who ended up with the backpack? You are not going to find out. You're not going to have any meaningful ballistics evidence. You're, like I mentioned, are going to hear that Mr. Williams spoke with Detective Benton soon after this. They didn't do any gunshot residue on him. You're not going to hear anything about whether they even attempted to see if he fired a shot. The most important thing that you are not going to see or hear in this shooting murder case is a gun. Per the indictment being read, 5 of these 10 counts are firearm related. 2 of them are felony murder predicated on possession of a firearm. Where is the firearm? Where is there a firearm tied to Raymond Williams? There's no gun tied to Mr. Williams, right, based on his fingerprints. No gun tied to Mr. Williams based on his DNA, because there is no gun. At the end of this trial, you are not going to know what happened. And you're certainly not gonna know who was involved. Not proven is not guilty. And because of that, once you hear the law from the judge and what reasonable doubt means, we will ask you to return the only verdict that the evidence is gonna support. And that is that Mel Williams is not guilty.
Thank you, Ms. Feely. Mr. Francis?
Mr. Tolbert was there. He was at the scene. He was there. He saw everything. He's a witness. He's gonna take this witness stand. He's gonna sit right here. And let me tell you right now, you're gonna see a whole lot of fidgeting. You're gonna see a whole lot of fidgeting from him through the whole trial. That's what you're gonna see. What he's gonna tell you is this: I had never been arrested for a felony. I've never been convicted of a felony. I was living in the home of Mel Williams and the other people for about a month and a half. I was homeless before that. I was paying them about $125 a week. I'm 25 years old. I'm out on the streets by myself. And I'm working at a temp agency. And that I don't have access to these keys, and I have never driven this vehicle. That's what he's gonna tell you. I've been in the vehicle, but I've never driven this vehicle. I don't have access to this vehicle. And that's what Mr. Laflour is gonna tell you. He doesn't drive this vehicle. That's her vehicle. And he's gonna tell you that it's Mel Williams in the vehicle. He's arrested in Chicago with Mel Williams. Mel Williams asked him to go to Chicago. He says, okay, I'm staying with you. There's opportunities in Chicago. Let's go. There's a murder warrant for Mr. Williams, not for Mr. Tolbert in Chicago. He gets arrested. He tells the police everything he knows. He says, I didn't have anything to do with this. He had no knowledge what was going on. He's gonna tell you. You'll see this video. He says, he's taking me to work early in the morning. He said, Mr. Williams says, that's the guy that robbed me. And he pulls the car around and approaches that guy. He doesn't have any knowledge that Mr. Williams is robbing this man. He didn't have any knowledge that Mr. Williams was going to shoot this man. He didn't know what was going on between the two of them. That's where he lives. So he didn't get involved, maybe like a concerned citizen should, but he didn't know what was going on at the time. He hears a gunshot just like Mr. White. He doesn't know actually who fired the gunshot or what happened. The next thing he knows, Mr. Williams gets in the car and doesn't say anything about it. And they go on about their way. He's not conspiring with Mr. Williams to commit any crime. He's gonna tell you that. He told the police that. He's gonna sit right here and tell you that. And that's all he has. That's it. That's all he has in the world. And that's what he told the police years ago. So pay particular attention to who said what and when, and what the evidence is. There's no physical evidence that Mr. Tolbert assaulted anybody, fired a gun at anybody, drove the vehicle that night, or anything. There's a fingerprint of his on the passenger side. Why? Because he's been in the vehicle. He's lived with Mr. Tolbert for about 1.5 to 2 months. He's been in the vehicle. He was in the vehicle that night on the passenger side. He was not in control of that vehicle. He had nothing to do with this and did not agree to participate in this. He's merely there. Somebody with no criminal record whatsoever, no history of guns whatsoever, is with the person who took him in as a homeless person. That's it. That's it. That is it. And he's going to tell you that. He's going to tell you that. It's your job to assess credibility, and maybe the judge will give you those instructions later. And that's it. So we ask that after listening to everything, we think there's only one verdict with respect to the charges against Mr. Tolbert, which is he is not a party to Mr. Williams' crime. He's not. He is not a conspirator with Mr. Williams. He's not. And that he is not guilty for the crimes that Mr. Williams committed. That's what we'll be asking for. Thank you.
Thank you, Mr. Francis. Mr. Trepanier, you ready with your first witness?
Would it be possible to have a 5-minute bathroom break, Your Honor?
You guys ready for your first break? They are. Well, you lucky this time, Mr. Trepanier. So ladies and gentlemen, before you go, this is your first break. Please don't talk about the case. You've just heard 3 different perspectives on what the evidence is or isn't. Those are lawyers' perspectives. It's not evidence. They're forecasts of what the evidence will be. Don't talk about that. Enjoy the snacks. If you run low on snacks, let Deputy Gordon know. You're free to check your phones for news or call people not to talk about the case. That hallway back there is an okay space for you to patrol. Don't make too much of a racket out there because my colleagues will come yell at me. But just if you want to stretch your legs, you can actually see sunlight all the way at the end of the hall. That's fine. Just sort of be kind of quiet when you're way down there. Any logistical questions before you step out? We'll get you back in here about 5-6 minutes. We actually won't end the break till you say you're done, but Deputy Gordon will let you know we're ready for you. And then if the 13 of you say thumbs up, we'll get you back in here. Thank you.
All right, good.
You all can be seated. So, Mr. Tolbert, it is real important for your continued presence in court that if you have a concern about something you think what's being said isn't right or you remember it differently, that I'm going to hear from you in a minute. I'm going to start, okay? That you communicate that quietly to the person who will actually be speaking on your behalf, and that's Mr. Francis. Let me finish. I promise I'll let you talk. The only time you should be saying something loud enough for the jurors to hear it is if you decide to testify. It sounds like you're going to do that, but you and I are actually going to have a conversation about that later on in the trial, because ultimately you decide, not Mr. Francis, whether you're going to testify. But before then, before you take the stand, the jurors really shouldn't hear anything you have to say. And if I feel like they're starting to hear it, I'm probably going to feel like you actually need to not be in the courtroom. You cannot have an outburst like that. You may have been exactly right. I couldn't really tell what you were saying, but you don't object. Mr. Francis does. And he may decide, as the expert on the topic, that, you know what, that's something I'm not going to object to. I promise you can talk. Let me finish. Mr. Francis makes the objections, not you. You can pass him a note saying, idiot, why aren't you objecting? And he's going to tell you why he's actually pretty smart about this. He doesn't want to interrupt that. He doesn't want to draw attention to it. Or in his professional judgment, that's not something he's going to object to. But that's his call. He's the boss of objecting, not you. You're the boss of whether you testify or not. That's not going to be for a few days. All right, I've said what I needed to say. What do you want to say?
Excuse me, Chairman Burton. You know, I don't need no disrespect, but this is my life. You heard me. You know what I'm saying? At the end of the day, this man gonna go home after whatever's said and done. You feel me? So I only have one chance. This man just told these folks that these folks, when they pulled these folks into investigation, now I'm reading the discovery. You told these folks that, oh yeah, the people that had possession of the car was Mr. Williams, Miss Alicia Laflour, then Anthony. But in this discovery, you asked 3 people. I know that my father told me, you go and ask 3 people something, and they say the same thing. What is that? The truth. You feel me? You went to ask 3 people who had possession of the car. All 3 people said, Raymond Williams, Alicia Laflour, Vanessa Williams. Where did Anthony Tolbert come in at? That's what I'm trying to ask. That's what I objected on.
Okay.
Where did Anthony Tolbert come in at? It's like you freestyling now.
Well, so you're free. So you're freestyling right now. It may. Okay.
Like you playing with a person.
Okay. I got you. Now I appreciate the stakes. Okay. Got it. There will be times, I have no doubt, when one of the prosecutors says something that really gets under your skin. That is just not what happened.
It really didn't get under my skin. You know what I'm saying? I'm just saying, like, if you want to tell these folks what happened, tell them the truth.
Okay.
You know what I'm saying? We're going to keep it at that, keep it on a man level. Tell it the truth.
Okay.
You know what I'm saying?
Yeah, I do know what you're saying.
I'm
And
trying to work to make it work to your ends, you know what I mean, to fit your ends, you know what I'm saying? If we gonna do it right,
Okay,
you know what I'm saying, that's all I'm saying.
I hear you. You need to,
Fair trial, not gonna be perfect, but, you know what I mean?
so two things on that. One, you and I are very aligned. I want this to be a fair trial. It is not unfair for one side to give their spin on the evidence. That's what happens. That's how it plays out. But your lawyer is very good at defending your rights in this situation. He just gave an opening that was very provocative, that the jurors are going to be thinking about, and was a rebuttal of what we heard from the prosecutor. You need to let him do those things and not draw attention away from that by suddenly blurting something out. If we need to take a break because there's something that you feel like you and I need to talk about, let Mr. Francis know, hey, we take a break, got to talk with the judge. But if you say stuff out loud like that again, I'm probably going to say, jurors, you need to step outside. And when they come back in, you're not going to be in here. And they may not think that's a real good thing on your behalf. So
You still do tell me that my life is on the line, you just gonna remove me from fighting for my life. That is wrong, Mr. Bernie. What happened to just petition to serve, bro? That is wrong. What happened to the hip? I'm not trying to be a distraction.
Good.
This is my life on the line.
good. Don't be a distraction. Don't be a distraction. Mr. Francis is protecting your rights. And if there's something that you feel like he needs to share, you need to send him a note as opposed to you objecting. You need to understand you cannot object again. If you again say objection, it'll be my turn to object to your disruption and say, for a little while, you're not going to be in the courtroom until you convince me that you can not object in court. The lawyers will object. If Mr. Francis is not objecting, that means in his strategic evaluation, you know what? That's why I'm going to let slide. I'm going to let Trepanier say that Tolbert had access to the car because he knows that no witness is going to say that. And so that just means the state has promised something they can't deliver. There's nothing remarkable about that at all. Defense attorneys love it when prosecutors say, you know what you're going to hear? You're going to hear X. Great, because they know they're not going to hear that. And so in your lawyer's closing, he's going to be able to say, you heard an opening that the state was going to show that Tolbert was driving that car. He had the keys. In fact, he had his own set of the keys. And then if no one says that, who looks bad? Do you look bad? You don't look bad. You look like you're trying to tell the truth and someone wasn't. So let your lawyer, who's the veteran here, manage this process. If you are having some issue that we need to talk about, just let someone know, time out. But I can't have you having an outburst like that. It makes the jurors nervous, and you don't want jurors to be nervous about you, do you? No, you don't. All right. Last question for now. Okay.
This thing says live. Can I have my folks just put in state versus the evidence all, state versus?
So there's a live YouTube feed. If they go to the Superior Court website, Fulton County website, there's a feed for each judge. They go to Judge McBurney and click on that. They would have heard you object in the middle of the opening. Okay. And you don't want your folks hearing that. Yeah. We've been working together. All of us in this room for a while to get this trial going. Let's not disrupt it. Okay. Mr. Trepanier, anything before you get your 5-minute bathroom break?
No, Judge.
Okay. Your witness will be ready after the 5-minute bathroom break. Okay. Ms. Feely, anything? All right. Mr. Francis, anything else?
No.
All right. I'll see you all a little before 11 on the clock on the wall. How are you, sir? I saw you come on in. What's new? Excellent. Doing well. Hey, intern, how are you? Nice to meet you. Excellent. Wow, look at that. We got all sorts of folks. Good. Not a problem. You guys are welcome whenever, and it is also available through the feed. I know some interns end up watching it that way. Oh my gosh. All right, then it's back to school. Good. Hey, how are you? Nice to meet you. Sure. Nice to meet you. So are you the LSU or the Cleveland State? Okay. LSU. All right. Nice to meet you. Congratulations on the baseball team. Yeah. All right. Well, now I get a 3-minute break, but I'll go do that. But hey, you guys are welcome to watch. And if we've got a break and you have questions, just let me know. Although he can answer all those questions. All right. Nice meeting you. Can I see you for a sec?
I guess so. I ain't want to be rude. I gotta introduce my you. I told that you want to. So they're gonna get it out.
Yeah.
I took the pen. We gotta stop.
I just have it pulled up. Yeah.
Coconut, I see.
Just that's how I've got my exhibit back. So I figured that's what.
Is Mr. Francis back with his client? Can we get Mr. Francis out here?
Just, you know, things change.
Can we get on the record?
Yes.
Great. We are back on the record. Mr. Francis, I would like you to check with your client about this, but it is my intention to make sure he is housed at a different facility from Mr. Williams from this moment onward. Are you okay with that or okay, I'm gonna make that happen. I've been told it can happen and I think it needs to happen. Unless you tell me, nope, he wants to be up close and personal.
I agree.
Okay, great. Mr. Trepanier, well, let's get the defendants out here, please. All right, Mr. Trepanier, anything we need to discuss before the jurors come back out?
No, Judge, I do want to say that I do believe our logistical issue probably has worked itself out, just so the court is aware.
The video situation.
No, I think we have it worked out, so.
Great.
I will keep the court updated though if that changes again with that software.
Okay. Ms. Feely, anything before the jurors come in?
No.
Mr. Francis?
No, we are.
Okay, scheduling wise, I have an exciting case management committee meeting at 12:30. So lunch will be starting just before 12:30. We'll run an hour, so it'll be basically 12:30 to 1:30 will be our lunch break. So we'll try to go until 12:30, hopefully without interruption. Let's bring the jurors in.
Rob, juror.
So it's helpful if you come in the row first, if you go all the way down the row rather than parking partway down, so people have to. Well, you don't. In fact, they don't want you to sit in the same spot every time. So why don't you move down one, and that way folks can just ease on in. Thank you.
All jurors are present and accounted for.
Thank you, Deputy Gordon. You all can be seated. So that was your first break. You did a great job. We worked through a couple things we needed to, and we are going to start with the state's first witness. That first witness is
State called Sharon Latners.
Ms. Latners. Come on up, please.
Raise my hand. You swear affirm that the testimony will give the truth, the whole truth, and nothing but the truth of God. Put my hand out, see. State and spell your name for the record.
Sharon Latners, SharonLatners.
Good morning, Ms. Latners.
Good morning.
How are you currently employed?
City of Atlanta Police Department.
And what do you do with the City of Atlanta Police Department?
I am custodian records for the 911 center.
And what does a custodian of records do?
I handle all incoming, outgoing 911 calls, all radio calls for the police department. I handle all the CAD reports, incident reports. I handle subpoenas and I testify in courts for all the DA's office.
What does the 911 call center do?
911 call center does is we have 18 911 operator on each shift to handle 911 calls. We have 8 dispatchers to handle radio side for the police side.
And when a 911 call comes in, what is produced as a record of that call?
It's a copy of the CAD report. On the CAD report, you have the incident number, the date of the call, what type of call it is, the locations, the time the call came in, the time the officer arrived on the call, time he cleared the call, and information that the caller provide to the operator to type in CAD report.
And is there audio of that 911 call?
Yes, our system recorded 24 hours.
Okay. So for each call, there would be a CAD report?
If you only ask for police, fire, or EMS, you'll get a CAD report.
Okay. How are 911 calls stored or kept?
They are stored in our system 24 hours.
Does this happen automatically?
Yes,
And you said they're stored for 24 hours?
they're stored in the system 24 hours to 24 hours. We keep them, since we take up 1 million calls through the city of Atlanta, we keep, we don't purge the system calls ourselves, the system purge it, because we take over 3 million calls a year. And after so many calls, the system purge it. So we might go back 3, maybe 4 years of audio that we keep. The CAD report we keep from 2000 to present.
When a person calls 911, is it automatically recorded?
Yes.
So it's not a dispatcher pressing a button, it's just automatically recorded.
Once the operator answers the call starts recording.
And when is the CAD report generated?
Once the operator press F4.
F4. How is it generated? Is it pressing that button or is there more to it?
She has to press F4.
How did you arrive at F4 rather than F3 or F5?
That's a system that we use through AT&T. We
Okay.
have certain codes, they use F4 mean CAD is created. F1 mean it goes to the dispatchers.
Okay.
And when is a CAD report finalized?
Once the officer pulled in, he's clear from that call.
Okay. Are CAD reports kept in the regular course of business at the 911 center?
Yes,
And why do you do that?
that's a state law. We have to have records of incident and CAD report communicating together.
And are these records, these CAD reports and these 911 calls kept as part of the regularly conducted activity of the 911 center?
Yes,
And is this your regular business practice?
yes, sir.
All right. I'm going to show you states exhibit 1, 2, and 3.
Do you have an exhibit list?
I do, Judge. I can submit that. It's a spreadsheet.
Okay.
So looking at exhibits 1, 2, and 3, what is exhibit 1?
One is a copy of the 911 call placed on this disk.
Okay. And did you have a chance to review that?
Yes,
Okay. And is that 911 call associated with any of the other exhibits that you have there?
yes, sir.
Okay. And what exhibit is it associated with?
The CAD reports.
Okay. What is exhibit 2?
It's a copy of the incident number, the CAD report for that date,
Okay. And what date is that?
January 14, 2019.
And were each of these exhibits provided by the 911 call center to the Fulton County District Attorney's Office?
Yes, sir.
All right. And are these a fair and accurate representation of the items that were provided to the Fulton County District Attorney's Office?
Yes,
Your Honor, this time the state would tender into evidence states exhibits 1, 2, and 3.
Ms. Feely?
No,
Mr. Francis?
Okay.
1 through 3 are admitted. I'll check them off on my air exhibit list right
Yes,
here.
Judge. Permission to publish, Your Honor?
Yes.
The state is not publishing states exhibit 1.
When you did screen share, did you check the little box that says also share audio and video?
Not.
What street is this?
Atlanta 911 for the 7087. What is the address?
Yes, we on North Side. We on North Side Drive. We need an ambulance.
North Side Drive.
North Side Drive. By what we buy? North Side Drive. Right here by the Chevron. Man was stabbed.
Okay, hold on 1 second.
The car proceeded. That what it look like?
This is Atlanta with the transfer. Ma'am, do you see another cross street with North Side?
The man standing here said this. What did you say? We're on 278 southbound.
278.
278 northbound. We by that sign. We by the Chevron. We looking at, is that a storage facility? I'm not sure.
Ma'am, are you on the highway?
No, we on a street.
On North Side Drive.
On North Side Drive. Coming around. Trying to find a sign. I don't know. Main Street is Northside Drive. It's the Chevron behind the gate. I'm looking at, I don't know, construction work. And then if I turn down the street where I saw the man, I see the sign that says 278 North. Northside Drive, North Avenue. Coming around the
Northside
curve.
Drive and North Avenue?
Yes. Yes, it is. Oh, shit.
Okay, ma'am, what's the phone number you're calling from?
They shot you. Oh.
They shot him.
You said what? Ma'am, I'm sorry.
He got
What's
shot.
the phone number you're calling from?
I don't have a phone number. My phone number is off, but I can, still make emergency calls.
Don't move. Don't move.
Okay, what's your name?
My name is Ashley. Right.
Okay, and you said he shot?
Yes, he just told me he got shot. I said sad, but we see a bullet case there right here on the ground, so he said they shot him.
Okay, how old is he?
Say it again, I'm sorry.
How old is he?
So she said don't move, but how old are you? How old are you, sir? 28? She said 28.
28?
Yes. How long have you been out here?
Ma'am, is he on North Side or is he on North Avenue?
North side.
North Side.
North Avenue, ma'am.
North Side and North Avenue.
I understand the intersection. I'm asking, are you at the right at the corner or are you on North Avenue?
We basically at the corner coming around the curve.
Call the police to the car, man.
Okay. Young man said Marta police is about to call.
Okay, Atlanta, I made 07. We're en route. What's your number?
7087.
Yeah.
I can't hear you.
7087.
Thank you. Ma'am, is he awake?
Yeah, he's awake. He just keep moving. I don't know how long he's been out here. He's breathing. He said it's hard to breathe because it's an upper thigh, it's above the knee, and I don't know. He didn't tell me how long he's been out here. I asked, he didn't answer.
Okay.
But it's a knife at the scene and a bullet casing at the scene as well. So
When did this happen?
we're not sure. Me and my friends were riding by, and my friend saw him, so she stopped. So I started dialing 911.
Can you ask him when it happened?
I'm now going to publish State's Exhibit 2. So looking at State's Exhibit number 2, Ms. Latners, what is State's Exhibit 2 associated with again?
CAD report.
Okay. And is this the CAD report associated with that 911 call?
Yes.
Okay. Looking at this CAD report, what time does it indicate and where that the 911 call was placed?
It was placed from a cell tower. They hit the nearest cell tower at 576 Northside Drive, Northwest.
Okay. And what time was the call made?
3:39 a.m. hours.
When it indicates received, what does that mean?
I mean, the operator sent a call over to the dispatcher to dispatch out to the unit.
And dispatched is the time that a unit is dispatched?
Yes.
And the next line, with 911, it says arrived, and it says 03, 44, and 17. What does that mean?
That means Officer advised his radio that he arrived on the scene.
And then there's a spot towards the right here that says cleared. What does that mean?
He advised dispatcher he cleared the call.
And what time was the call cleared?
06:46 a.m. hours.
There's an area here for unit information. What does that indicate to you?
where it shows primary unit 4130, but that's a homicide unit. After everything is cleared out, homicide takes over the call, so he's gonna be the primary unit to do the report on this call.
And what does unit times mean, this next area?
Let's say section unit.
A little bit on the second page, page 2, where it indicates unit times. What does that page indicate to you?
That just shows you what time the officer arrived on the scene. They shows backup times, en route times.
What is I'm now on page 3 of the CAD report. What is a CAD narrative?
That's the information that the call taker received from the caller. Then you see some more down at the bottom. Dispatcher received the information from the officer, and they just types whatever they get from the information from the officer and the caller.
Okay. Published States Exhibit 3.
Bless you.
What is States Exhibit 3?
Top of the CAD report.
Okay. And what is the caller information related to this?
Shots fired.
And how did that, how is this report, CAD report, generated?
It's generated through the supervisor. Back in 2018, the city purchased the system for shots fired in certain area, which was zone 1 and zone 6. So they was getting so many shots fired in the area. So whenever that system picks up shot fired, it goes to the supervisor podium, and they create an incident for that, a CAD report for it, and send officers out there.
All right. And that's what CAD report, or that's what States Exhibit 3 represents.
Yes.
And just so everybody is clear, you're not the 911 operator on any of these calls, correct?
No, sir.
All right. And you're not a dispatcher on any of these calls?
No, sir.
Okay. And each of these CAD reports and 911 calls, are they generated at the time of the incident?
Yes, sir.
No further questions, subject to redirect.
Ms. Feely, do you have any questions for Ms. Latners?
I do not, thank you.
Mr. Francis, any questions from the jurors for Ms. Latners? Seeing none, thank you, ma'am, for being here. Appreciate it. You can leave the exhibits right there. Your next witness.
You got a state called Sharita Thomas.
Hello, Ms. Thomas. If you could, before you take a seat, turn towards Deputy Gordon. He's going to swear you in.
You swear affirm the testimony you will give, the truth, the whole truth, and nothing but truth, so help you God. Yes. The Lord in house.
Sharita Thomas, Sheretta Thomas.
Good morning, Ms. Thomas. How you doing today?
I'm great. How about yourself?
All right, if I can have, make sure you speak into the microphone so we can hear everything that you're saying.
Yes.
All right. Now, Ms. Thomas, do you remember meeting me last week?
Yes.
Okay, coming to our office and Mr. Treppian?
Yes.
Okay, and in particular, do you recall what we wanted to talk to you about? Do you recall that?
The incident with, with the car going by and the suspect.
Okay, let me turn your attention to that time period. So we're talking about January 13, 14, 2019.
I don't remember the date, but yes.
All right. Do you recall in 2019 if you were ever working as a security guard?
Allied,
At Allied?
Dallas, Northside Drive.
Okay. What types of what type of things would you do as a security guard?
I sit outside and watch the surroundings, the vehicles, the patients come in and out and make sure they're safe.
Okay.
And I seen a vehicle going up and down the street, and I left my post and went to the store.
All right. Let me ask you this. You recall around what time of day this was?
It was like midnight. It was maybe a little bit, because I worked sometimes I would do a double. I would work from 4 to 12 and then sometimes 12 to 10. And if I went in, I would get off at like 4 in the morning. So I walked to the store. But I had been sitting outside, the patients sleep at night. And once they doing dialysis, so I took a walk to the store. But before I took the walk, I don't know whether the car was gray or silver or whatever, but it kept circling the block. So once
Do you remember how many times you say circling, how many times you saw that?
I want to say like 4 times.
All right.
I didn't hear that. That's what's wrong.
4.
Was it anything about your observation of that car that made you pay special attention to it?
I was security.
Okay.
So it was tinted windows. And next thing I knew, it was gunshots.
All right. So when you were seeing the car, you said it passed.
It'll go down. Okay, if you go down Northside Drive, and then it came back up Northside Drive. Then it come back down. And once I was coming back, I don't know who recorded me. Was it the police? I don't really recall, but I do recall hearing the gunshots. And that's all.
So as you're watching the vehicle circle, are you thinking anything at that time?
It was strange.
Okay. What do you mean by that?
Something not right.
It didn't feel right to you. That's enough.
Okay.
So you have to give it all the answers so we can hear you.
Okay, I'm sorry. I apologize.
No, it's all good. You're welcome to shake your head as much as you want, but just make sure you add a word to it if it's a yes or a no.
I'm sorry, but I knew it was something strange going on.
Okay.
Once you see a vehicle just circling the block, you're either looking for somebody or you done lost something. So next thing you know, once I walked to the convenience store, and once I came back, I stopped and I talked and said, I had seen the vehicle and it looked strange.
All right. How soon after you see the vehicle where you get the gunshots?
I come out, I think it's Chevron right there at the Marathon gas station. So it was like 6 minutes. By the time I took a good 5-minute walk, I heard the gunshots.
Okay.
And that
you said shots. So are you talking one gunshot or are you talking about several?
I really can't recall.
I can't recall, but you would the sound you recognize is a gunshot.
Yes.
What did you do after you heard that gunshot?
I stopped and looked around, and that's why I don't recall remembering being on. I don't know whether it was the family members or the police. I just wanted to speak on it because I know it was a tragedy.
Okay, all right. So is it your testimony that you took initiative to make contact with law enforcement?
That's my duty. I'm security, but and I did. I think I called the police. I don't recall. It's been a couple of years.
Sure. And that location where you,
Northside Drive, Dallas,
is that in Fulton County, the location you testified?
Atlanta, Dallas, Atlanta, Northside Drive. I don't even remember the address.
That's all I have to say.
Okay. Ms. Feely, do you have any questions for Ms. Thomas?
I do not, thank you.
Mr. Francis, questions for Ms. Thomas? Okay.
Hey, Ms. Thomas,
Hi,
how are you?
great.
I just want to make sure I'm taking notes, and I just want to make sure I wrote down accurately what you said. So you don't recall whether you called the police or not?
I knew the police, really the police was, basically they circle the block. Northside is a heavy, with traffic and violence. So I didn't call them.
Okay. Were you there when the police arrived? Do you recall?
I think once I walked out the convenience store and I was walking up, I think I stopped and talked to the police. I don't know who was camcording it, whether it was the police or not, because I actually had forgot this incident.
When did you forget this incident?
It's been 2019.
Okay.
So I forgot. But I do recall once they showed me the video, I recall that moment.
Okay.
So
Mhm.
can I say this?
I don't know. Why don't we let's let Mr. Francis ask another question and we'll see where we go with that.
And when you say, who showed you the video?
So you're pointing to the prosecutors.
Right.
Yes.
Okay. The gentleman, Mr. Fossett, just asked you met with the prosecutors. When you met with them, they showed a video to you.
And it was me. And I remember talking, but I don't know who called, but I didn't call. But once I got that, because I didn't supposed to leave my job site.
Okay. So would it be fair to say that your memory about what happened is not the best?
Exactly.
Okay. Now, but here's the real question I want to drill down. If your memory is not the best, how can we be certain that you saw the car circle 4 times?
Because I was sitting outside at the dialysis in the chair outside. I was sitting outside on work duty, but it was in the mid-morning and I didn't drive my car. I just walked to the store and I didn't know this incident was gonna happen. Basically.
Okay. So you were 100% certain that you saw the car circle 4 times. And what color was the car again?
I say gray.
Gray. Do you know what type of car it was?
I want to say a Honda Civic or something like that, a Nissan. I can't.
But you didn't make note of the license plate, did you?
No, sir. If I did, I would give you the numbers because I'm a gambler.
Okay. And you can't say for certain whether there was another car in the area that looked like that car?
No, I watched the car. I watched my surroundings,
Okay.
honestly.
Did you tell the police that you saw the car circling 4 times? Who did you tell? Wait, well, we got to get your answer on the record.
I don't really know if it was an officer or if it was a family member because people showed up on the scene real quick. They showed up. So I don't know who was videoing me. But when I know these 2 gentlemen showed me, I do recall that incident. But I did see the car.
So in the video that you saw,
It was a gray car.
was that exactly what you saw, or did you
Yes,
see
sir.
more than? Well, let me finish. In the video that you were shown, is that all that you saw that night, or did you see even more that night?
Okay. Once I left out of the Chevron, my back was turned, and then I heard the gunshot. I don't know whether it was one shot, but I'm trying to save me.
Right. Well, let me ask a better question. You were shown the video by the prosecutors. Okay. Did that night before the gunshot, did you see more than what's in the video that was shown to you, or the same that was in the video?
You have to
More or
say,
less.
No, I'm sorry. No, sir.
So what you saw, what we will see on the video is exactly what you saw, nothing more.
No, sir.
Okay, that's all I wanted to drill down on. Thank you.
Mhm.
do you have any redirect?
No, Judge, just one question for Ms. Thomas. Ms. Thomas, is it still your testimony that your observation of the circle was strange for you and suspicious?
It's, I want justice
Hold
to
on
be
one second.
served.
Don't answer. The objection was calls for speculation.
Well, she's testifying as to what she felt and believed at the time it was happening.
Overruled.
Is it still your testimony that what you observed as far as a vehicle passing by your location, that was suspicious to you at the
That
time?
was suspicious and it's straight up honest.
That's all I have, Judge.
Jurors, do you have any questions for Ms. Thomas? Seeing none. Ms. Thomas, thank you for being here. I appreciate it. Is Ms. Thomas free to go?
No objection.
Okay, thank you, ma'am. Appreciate it. Okay, you need to keep going, Ms. Thomas. And ladies and gentlemen, I need you all to step into the jury room.
All right, jurors.
All right, be seated, please. Ms. Feely, I'll start with you.
I have no choice but to move from this trial.
For what reason?
The witness, as she was stepping down, when she was right up next to the jury, said to the jury, I hope that you give justice to the family.
Okay. Mr. Francis?
I concur, Your Honor, and she even made a comment under cross-examination, I believe, something similar. So she's clearly, I believe that her testimony may appear to now have been shaded towards the family based on her personal feelings. I mean, the witnesses have personal feelings, and I get that. But you know, she's made that comment to the jurors. She made a similar comment while I believe under cross-examination.
Help me with that one. I'm agreeing with you and Ms. Feely that Ms. Thomas just addressed the jury and said what she said. But I'm trying to remember in your exchange with her, what would have fallen anywhere near that category?
She didn't finish it, but it was something towards that end.
Okay.
She was in a lot of different places.
She was.
Clearly, I support Ms. Feely's motion that we move for mistrial because we can't strike that provision that statement that she just made to the jurors.
Okay. Mr. Fossett, this was your witness, so I'll let you bear the burden for the state.
Okay, thank you, Judge. Well, let me just say that clearly, just so I can say it, that obviously was something that was unanticipated by the state, unprovoked by the state, and that the witness on her own with no preparation chose to do that. Okay. We don't know what the jurors heard, how many of them heard it, or if it had any effect on them. So that would be the first thing I would say. I heard a comment that was, from what I heard, referencing justice for the family. I think that was all I heard. So whatever context the jury took that in is another consideration. I will just say as well, when Ms. Thomas presented to us in our office, she presented the same way, and that was someone who probably is intoxicated. I don't know if that's reflected in the record, but you know, I didn't know if she was going to be able to stand up straight, to be honest with you, considering how she presented this morning. So I don't, who knows if the jury, what credibility or weight they're putting on her testimony. I would ask the court to consider giving the jury an instruction that they are to disregard that statement. I think based off of what they may or may not have heard, that should be sufficient to ensure that these defendants get a fair trial.
Okay. Ms. Feely, if I deny your motion, my thought would be that it would be helpful to tell the jurors to disregard it, that wasn't appropriate, et cetera. But you may not want me to draw attention to it. So I want to get your thoughts about if I deny your motion, whether a instruction to the jury to disregard that's not something that they should weigh in terms of their decision-making, although both of you may want to reference it in your closing as to the amount of credibility to give to Ms. Thomas if we make it all the way to closings. But I want to get your thoughts about what a instruction would sound like.
So I'm messaging with my appellate section now to try to help the court hopefully draft a curative instruction. Obviously, we feel very strongly that this is mistrial-worthy. And I also just wanted to point out for the record that she was standing right by the jury and I heard what she said, as well as Mr. Francis, who's even further from where the speaker was. So I don't think that there's an issue of whether they heard it or not.
Let me pause you for a second. I know you're going to help me with thoughts about what the instruction would be. A different step, I don't advise it, but I want to present it to you and Mr. Francis, would be that we bring the jurors in one by one and say, did you hear what she said? And did it have an impact on you? That seems particularly invasive and putting a whole lot of emphasis on what I'm going to tell them to disregard. And so I didn't mean to skip over that as an option because all those things ran through my head. I think the right thing, you think the right thing is to grant your motion. I get that. Assuming I'm not going to do that, then we are either, we say nothing and just bring them back in, or I tell them something to the effect of, you may have heard Ms. Thomas saying something spontaneous on her way out. You need to disregard that insofar as it advocated for anything that's not her role, and that's nothing you should consider in any way during your deliberations.
That would be my preference for the next thing when they all come out of the court addresses.
Okay.
We do have to renew our motion.
That's fine. I'll let you renew it at least once after I do that. Mr. Francis.
I would agree, Judge. I would add that you just instruct the jury they're not to consider any spontaneous utterances or anything from a witness once they're off the witness stand and have been excused. And that, of course, part of your instructions is not to judge this case by sympathy or passion. I think that would cover it.
Okay.
I think that would be sufficient.
Okay. Thank you. Then let's bring the jurors back in. Bonus break.
All right, the jurors. Jury President accounted for.
Thank you, Deputy Gordon. Everyone, please be seated. Ladies and gentlemen, as Ms. Thomas was leaving the courtroom, she spontaneously engaged you all. That wasn't appropriate on her part. I don't know that she knew better or not, but you all need to disregard what she said. It was and is not evidence. It's nothing she said in response to a question. In fact, you should disregard anything you hear witnesses say after they've left the stand. They may say goodbye to someone. They may say, can you please sign my subpoena because I came here? And that's all outside the realm of what you should be considering. And in particular, if a witness in walking out of the courtroom turns to you all and says something, she said what she said, she's on her way. You need to disregard that. I will be telling you at the end of the trial, and I was going to wait till then, but I'm going to say it now as well, It is important that you decide this case based on your findings about the evidence and not because of any sympathy or affection or feelings for one side or the other. You are neutral in that respect. The facts are whatever you decide them to be. You decide if those facts satisfy the state's burden. If they don't, not guilty. If they do, you would be authorized to convict. So this is not about feeling a particular way about a family or a person or anything like that. So please do disregard her comments and anything else any other witness may say while heading out of the courtroom. Hopefully that doesn't happen again. Mr. Trepanier, before you do that, anything you want to add to the record?
Yeah, sure. Just for purposes of the record, we believe that the curative instruction was insufficient and we just renew our motion.
Okay, Mr. Francis?
I have to diverge, and I believe the curative instruction is sufficient.
All right, thanks. Mr. Trepanier, next witness.
State calls Sergeant Bart Metler.
How's that exhibit list coming? Is that going to be an after lunch thing?
I can email it to everybody once we're on a break.
I'd like a hard copy. So how about when you come back from lunch, you bring an exhibit list?
Yep.
Thank you.
You see what part that testimony will be up? The whole truth, nothing but truth on God. I do. So go ahead and have a seat.
My name is Jesse Barmettler, Jesse Barmettler.
And is it Sergeant Bart Metler?
It is.
Okay. Sergeant Bart Metler, where are you currently employed?
I'm employed by the City of Atlanta Police Department.
How long have you been employed there?
18 years.
And what are your kind of, as a sergeant, what are your roles and responsibilities?
My current assignment as a shift supervisor, I supervise officers and notify my chain of command of serious incidents and respond to certain incidents and to make sure that the officers are doing what they're supposed to be, policies being followed, and take control of those scenes and events.
Are you post-certified?
Yes, sir, I am.
And what does it mean to be post-certified, just briefly?
The post-certified is like the peace officers standardized training. It in order to be a police officer or a peace officer, sheriff's deputy, to be able to effect an arrest, there's a state mandated training and curriculum that has to be followed, and that has to be continuously followed throughout the years with follow-on training.
And in excuse me, in January 14th of 2019, where were you employed?
At the City of Atlanta Police Department.
Okay. And what was your role at that time?
I was a morning watch supervisor, a 911 supervisor,
Okay.
so like the officers that respond to 911 calls.
Okay, so I'm just going to break that down because there's, I think, a lot of terms there that may be
Sure.
unfamiliar. So morning watch, what is morning watch?
Morning watch is the third watch. It's 911, of course, provides 24 hours a day coverage for 911 calls to be response. So that's what we call our third watch, which is the overnight watch or the graveyard shift. It's about 8 hours. It was an 8-hour shift back then, starting at about 10:30 p.m., going to about 6:30 a.m.
And you indicated that you were a 911 supervisor. Is that different than other sorts of supervisors? Or?
There are different supervisors. When I say 911, I meant I was on the road as a 911. The morning watch is just your regular police officers in blue uniforms that drive blue cars and come to 911 calls.
Okay. And you're just the supervisor of some of those other officers?
Correct. One of them. Yes.
Okay. And what area on January 14th, 2019, were you assigned to in Atlanta?
I was Zone 1.
Okay. And generally, kind of what does Zone 1 cover?
Roughly northwest Atlanta.
Okay. On that date, did you respond to any incidents that you found to be significant?
There was a shooting, yes.
Okay. Do you know where that shooting was? You remember?
I think it was on North Side Avenue.
Would it have been Northside Drive or Northside Avenue?
Northside Drive. It was near the Georgia Tech campus.
Okay. What county is that in?
Fulton County, sir.
So when you, do you remember sort of what time of day that was?
It would have been early in the morning.
Okay. For you, what's early in the morning?
Oh,
Since you're
so
working
no,
on
that
morning
would have
watch
been if it
shift?
was on.
Stop. Gotta make sure you guys don't speak over each other. Court reporter can take down one voice at a time. So you may know the answer to the question. There's no early buzzing in. Wait till the question's all the way out. And then Mr. Trepanier, of course, let your witness finish answering before you try to say, wait, that's not what I was asking about. Let's restart.
So what is early morning for you?
It would have 1, 2, 3 o'clock in the morning.
Do you remember responding to the Northside Drive location?
I do, sir.
Okay. What do you remember seeing when you got there?
When I arrived with Sergeant Thompson, some APD units were there, some Georgia Tech units were there, and as well as some medical personnel.
And you mentioned medical personnel. Why were they there?
Oh, and it was the scene of a shooting.
Okay. Was a victim on scene at the time you arrived?
Yes, sir.
Okay. Do you remember what he looked like at all?
He was an African-American male. He was on the ground and he was being treated by the medical personnel.
Did you try to talk to him at all?
I did.
Okay. Were you able to, was he able to respond to your questions at all?
He did not.
Okay. Was he saying anything while you were there?
He said that medical personnel were trying to restrain him to a backboard for transport, and he was kind of resisting that. And then, but he did call out, not to me directly, but he did call out, "I can't breathe. I can't breathe."
I'm showing you what I've marked as State's Exhibit 5. You recognize that?
Yes, sir.
How do you recognize that?
It's a thumb drive that, to the best of my knowledge, contains the video from my body worn camera that I was wearing at the time I responded to Northside Drive.
And did you have a chance to review your body worn camera?
Yes, sir.
Okay. And is that body worn camera a fair and accurate representation of what was happening that day?
Yes, sir.
That morning? Your Honor, at this time, the state would tender State's Exhibit 5.
Any objection to States 5, Ms. Feely?
No, Your Honor.
Mr. Francis?
Okay.
Admitted.
And permission to publish a brief section, Your Honor?
Okay.
I'm publishing State's Exhibit 5 from 3 minutes and 17 seconds.
Here, well, you're all right. Here, it'll be up there if we find one. Who did this to you, man? Who did this to you?
Sir, you want us to help you out? You go ahead and stay on. You go ahead and stay on this backboard, man. Come on now. Come on.
Sir, who did this to you, man? What happened?
I can't breathe. I can't breathe.
Why can't you breathe? Sorry. Oh, just a round? Cartridge? Yeah, okay.
I'm ending publishing at 5 minutes of State's Exhibit 5.
So when you were on scene, were you walking the area?
Yes, sir.
Okay. And were you one of the first officers that was there?
I would say no. There were several other officers prior to my arrival.
Okay. When you were there, were items laying around the scene?
Yes.
Okay. Did you happen to see what we call ballistics or firearm evidence?
Yes. Yes, I did.
Okay. Did you happen to see any sort of black book bag?
No, sir.
Did anybody make you aware that whether or not there was a black book bag there?
On the scene?
Yes.
By the time we arrived? No, sir.
Now, as a supervisor on the scene, what did you do next?
Well, when I arrived, I wanted to make sure that the officers were responding appropriately. They were rendering aid, which at that point had been handled by the on-scene paramedics. I assigned an officer to start a crime scene log, which is just a log with the names of everybody that's there on the scene. And then we have to delineate the area that we think is the crime scene and that we restrict access to that. We, the police tape you see, we put that up to make sure that any evidence that we see is secured and won't be tampered with. And we also, any witnesses or anybody like that, we kind of sequester them and wait there and notify, depending on the type of scene, notify the appropriate investigatory response.
Okay. So in this situation, did you secure the crime scene?
Yes, sir.
Okay. Did that involve crime scene tape?
It did, sir.
Okay. Because of that location, do you remember how you secure a crime scene like that?
I can't recall exactly how that one was done, but usually that bigger is better for crime scenes. So I know we closed off several lanes of traffic. I do remember that.
And when officers arrive, did they tell you that they were moving things around or anything like that?
In terms of evidence?
Evidence.
No.
Okay. So all of the evidence that was there would have remained there?
Yes.
Okay. And is that just standard procedure?
Yes, sir, it is.
Okay. Is that something that officers learn in, like becoming post-certified?
Yes, sir, it is.
Okay. Did you remain on that scene or did you go elsewhere?
I did go elsewhere while the scene was active. Yes.
And where did you go?
I went to the Georgia Tech Police Department precinct, located on Georgia Tech.
Why did you do that?
One of the Georgia Tech police officers pointed out that his police department had a camera nearby that might have covered the area that we were looking at.
Okay. Were you able to determine whether there was video that covered that area?
Yes, sir.
Okay. And were you able to obtain that video?
Yes, sir, from the Georgia Tech PD.
Okay. And then once you get that, I mean, do you hold on to it or what happens with that evidence?
I took possession of it from Georgia Tech PD. They burned us a copy. I took it. I surrendered that copy over to the homicide investigators that came to the scene.
Okay. Do you do any sort of additional investigation after you go to a scene like that?
Me personally?
Yes.
No.
Okay. Is that turned over to other investigators?
Indeed, the appropriate investigative group.
And when you say the appropriate investigative group, just what does that mean?
And well, in this case, it was homicide.
Okay. Just not. No further questions, subject to redirect, Your Honor.
Okay. Ms. Feely, questions for Sergeant Bart.
You testified on direct that you were not the first officer on the scene, right?
That's correct.
And in fact, we could see other police officers on your body worn camera, right?
That's correct.
But it's my understanding that the crime scene was not established until you got there.
No, ma'am. The officers established a crime scene. As I respond, I am to ensure that they are properly establishing a crime scene.
So you're the one who put up the police tape?
I think I know I put up some police tape, but that's not necessarily my job. My job is to ensure that police tape is put up, for instance.
Thank you.
Mr. Francis, any questions for Sergeant Bart?
No question.
Any redirect?
No, Your Honor.
Okay, questions from the jurors? Seeing none. Thank you, Sergeant, for your time.
Sir.
Next witness. As you're thinking about it, if you're shuffling witnesses around, we're going to need to break for lunch in about 20 minutes. If that means we pause partway through a witness, that's fine. But just know that in about 20 minutes, we need to, a little less than 20 minutes, we need to pause. And if one of you could collect the exhibits, it's starting to get crowded there for the next witness. Who is this?
This is Special Agent Brewer.
Raise your right hand. You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but truth so help you God. Yes. Put your right hand on your seat. Say the spelling name for record.
Special Agent Jason Brewer, JASON BREWER.
Just so I get your title, are you Agent Brewer? What's your title?
Yes, Special Agent.
Special Agent, okay. Where are you currently employed?
The Georgia Department of Revenue.
How long have you been employed there?
7 months.
What's your current, I guess, role or responsibility there?
The Alcohol and Tobacco Division.
Prior to there, where were you employed?
Prior to that, I was the City of Kennesaw Police Department for a year and a half, and before that, the Georgia Tech Police Department for 11 years.
What were your roles and responsibilities of the Georgia Tech Police Department?
I was a sergeant in the patrol division.
And as a sergeant in a patrol division, what were your, I guess, your duties?
Supervise a shift of officers and as well as dispatch.
Do you remember on January 14th, 2019, between 3 and 4 a.m., were you working at the Georgia Tech Police Department?
Yes.
Okay. Does anything about that night and that morning stick out in your mind?
I remember we got the call of a incident that happened on Northside Drive across the street from our property.
Okay. And do you remember what that address was?
I believe it was 596 Northside Drive.
What county was that in?
Fulton County.
Is that area near Georgia Tech?
Yes, it's directly across the street from Georgia Tech property.
Okay. What property is across the street?
There's a warehouse as well as a shared facility with Georgia Power.
Did you or Georgia Tech Police Department maintain any surveillance video cameras in that location?
Yes, there are two cameras there. One faces the entrance to the warehouse. Another one also covers partially the power plant and Northside Drive.
Did you have access to the cameras on that date?
Yes, the cameras showed in dispatch, and I also had access at the computer on my desk at the police station.
And so you spoke quickly, so I'm just going to clarify. So you had access at dispatch?
Yes, the cameras were controlled by dispatchers, but I could also control it and view any of the cameras from my desk.
Okay.
The computer on my desk.
All right. Were those cameras functioning properly on that date?
Yes.
Okay. On that date, did you at that point receive a possible description of a suspect vehicle?
Yes, we heard that had a time frame of, I believe, 3:30 to 3:40, somewhere in that area, and a description of a boxy gray SUV.
Were the Georgia Tech Police Department cameras able to capture video of the vehicle?
Yes, when I got that information, I checked the cameras during that roughly that time frame, see if I could find the vehicle, and I believe I did, and I relayed that information to the Atlanta Police Department.
Do those Georgia Tech Police Department cameras record?
Yes.
Okay.
The recordings are saved for 30 days, and then we can access it anytime and save video as well.
Okay. Did you generate a copy of that recording from the camera that day?
Yes. I believe Sergeant Barmletter came to the department, and I showed him exactly what I had found, and then we transferred a copy of that onto a disk for him.
Okay. I'm showing you a copy of what's been marked as State's Exhibit 4. You recognize that?
Yes.
How do you recognize that?
That is the jump drive that I believe you put the video on from the disk.
Okay. Did you have a chance to review that?
Yes.
Okay. And after reviewed that, what mark did you make on it?
I initialed the corner of the envelope.
Okay. And upon reviewing that, was that an accurate recording of the video from January 14, 2019?
Yes.
Okay. And was that the video that you had provided to the Atlanta Police Department?
Yes.
And at this time, the state would tender Exhibit 4 in evidence.
Any objection to States 4, Ms. Feely?
No.
Mr. Francis, 4 is admitted.
Is it typical for you to utilize those cameras to assist other agencies?
Yes, that was very common. We have cameras all around the, on campus as well as just outside of campus. That was a very common occurrence.
Apart from providing this surveillance video in this case, were you involved in it any further?
No.
Your Honor, permission to publish states Exhibit 4?
Granted.
Publishing States Exhibit 4 beginning at timestamp of 3:32 and 59 a.m., which indicates Monday, January 14, 2019.
Is this north side that we're looking at?
Yes, sir.
And I posited 3:33 and 13 a.m. Do we see, what do we see in the video itself?
I see a person walking down on the west side of the street with a backpack.
Were you made aware of who that person could be?
Yes.
What was your understanding of who that was?
It was my understanding that was the victim of the shooting.
I'm resuming playback.
So is that person walking southbound?
Yes, sir.
I paused at 3:35:02. Was that the suspect vehicle?
Yes, that's what I understood to be the description, master description of the suspect vehicle.
Resuming playback. Pausing at 3:36 in 2 seconds. Were you aware of where the incident location was in reference to this camera?
I believe that it was behind the, that power pole that's right there to the left of the camera.
Was that the suspect vehicle that backed into that location and then
Yes.
pulled back out?
Yes, that was the same one backing up.
Now traveling north on Northside Drive?
Yes, on Northside Drive towards Donnelly Hollow.
Pausing at 3:37 and 24.
No further questions, subject to redirect.
Ms. Feely, questions for Agent Brewer?
No questions, thank you.
Mr. Francis?
No questions.
Jurors? All right, Agent, thank you for your time.
Thank you, Your Honor.
Go collect some taxes. So I think we'll pause here. It's about 3 or 4 minutes early. I try to get that perfect touchdown where we end right when we need to end, but I need to talk with you all about stuff anyway. So ladies and gentlemen, your first lunch break. I know the morning's been a little choppy. We had a few breaks, but we've got 4 witnesses under our belt already, which is great. You are free to go out for lunch. You are free to eat as a group. You're not required to eat together as a group. You can subdivide however you want. The one requirement, it's really 2, don't talk about the case and no outside research. If you had questions for any of those witnesses, you should have written them down on a card and then I would pose them if they were proper questions to those witnesses. But you didn't, which is fine, which means you shouldn't have any need to look anything up online because you heard what you needed to hear from those witnesses. Enjoy your lunch. We're going to try to start up at 1:30. We can't start unless all 13 of you are back. So if someone looks like she's wandering far away, reel them back in. You're welcome to eat in the jury room. There is a fridge in there. You can bring food in tomorrow. You didn't know what to do today. The one thing you can't bring in, the many things you can't bring in, glass or metal. If you bring a glass container or a fork or a knife that's made out of metal, those will be held by the deputies and you can't bring them in. So bring in plastic, paper, whatever. But you're also welcome to go out. Any logistical questions from you? Okay, we'll see you as close to 1:30 as we can make it happen. Thank you. You all can be seated, except Ms. Sabnis. I need you to come sit in the jury box, please. And while she's coming up, prosecutors, if you two could partner on the AV work, it would be great. If you know you're going to be playing states 5 through a witness, if Mr. Fawcett could be getting it teed up, even though you may be driving it, we get these pauses in here while you're trying to get it all loaded in. And you've got a colleague who could help make that happen. You are juror 6. It is 12:24 in the afternoon. You were supposed to be here at 9 this morning. When you were contacted last night, you didn't say, I'm not coming in. When you were contacted this morning about where you were, the answer was Roswell, and you had classes to go to. And the 13 jurors who would have been your colleagues sat around for 30 minutes while we tried to figure out what was going on. Then your tummy wasn't feeling well, so you went to urgent care. And we were stuck, not able to proceed because you had decided that going to class was more important than serving as a juror. Anything you want to share with the group that's here?
So yesterday, when I called in, I asked if I could get the night off because I was working. So I called in and asked about that, and she said I could get tonight off, but I couldn't get yesterday night off. The whole reason why I've been feeling nauseous is because I worked all night and I go back home to take a shower and I was driving back here. So it's not that I don't want to participate, it's that I had prior responsibilities. I've also submitted an affidavit for being a full-time student. I have it notarized and everything, so if you need that, I can do that.
Okay.
I have a note from the doctor and he.
Okay. So that affidavit about being a full-time student will be great next time you're selected to serve. That's something we would have needed before yesterday, or I guess during yesterday, but it's a little late now. We've managed to limp along without you. We're down one juror, and that makes things complicated for everyone involved. I'm sorry you couldn't get last night off. I know we had a discussion about that, where ideally you'd get last night off, but if you couldn't, you still needed to be here, and you weren't. And to be clear, what was relayed to me is that when my staff contacted you this morning, it wasn't, I had to work last night, it's, I got to go to class today. And we worked through that yesterday, and you didn't bring it up when we let you know you had been selected to serve. But that's water under the bridge. We are going to move forward without you as a juror. I appreciate you coming down here and wish you the best with your other responsibilities. If you are brought in for jury duty in the future, either get that affidavit in advance or show up when you're told to show up.
Okay, can I get something that you said spelled yesterday?
Yes, if you want to come back at 1:30, we can have that for you about yesterday. I don't know about today. I'll have to think about that because you really weren't here when we needed you today, but certainly for yesterday. But I can get that letter generated, but you'll need to be back here at 1:30. Okay?
You need my note?
I don't. All right, so we'll get an exhibit list after lunch break, and you guys will huddle up about assisting each other with the AV work. And Mr. Francis, I put in a formal request for the housing situation I talked to you about. If I get any feedback, I'll let you know. And that's it for my list. Mr. Trepanier, anything before we break?
Nothing from the state.
You'll have witness ready to go by 1:30?
Yes, Your Honor.
Fill our afternoon?
Yes, Your Honor.
Okay. Ms. Feely, anything? No. Mr. Francis? No, Your Honor. All right, see you all about 1:30. And I'll mute the microphone in here. 1 second. All right, our audio should be back on. Get the defendants. Oh, look at this exhibit list. This is it? It all fits on one page. That's great.
Yeah, well, so for example,
I see 6 through 45 is one line item, but that's all I don't need to know that one is a shell casing and the other is.
honestly, like if there might be a couple additions towards the end, but for the most part, I think this is.
Life happens. I get it. Okay, great. This will allow me to keep track. Thank you. Who is your next witness going to be?
It's going to be Al Vasquez.
Okay. Is he getting them? Okay. Mr. Williams, you doing okay? You've been very quiet.
Yeah.
Quiet is fine. I just want to make sure you're doing okay. And our jurors are ready. I know we're waiting on Mr. Tolbert, but they're ready to go. Okay. Okay, Ms. Rivers, you ready? Yes. We are back on the record in State versus Williams and Tolbert. We've got everyone that we need to have in court, both defendants, their lawyers, and prosecutors. Mr. Trepanier, anything before we bring the jury back in?
Nothing from the state judge.
Ms. Feely?
No.
Mr. Francis?
No, Your Honor.
Okay, great. Let's bring the jurors in. Juror 6 didn't come back. Well, I don't see. I mean, she didn't have to. It was come back if you want your letter. Yeah, that's right. She's not 30 minutes late yet.
All right, Mr. Juror.
Yeah, she's not here, but if she comes back, we're ready for her. Thank you.
All jurors are present and accounted for.
Thank you, Deputy Gordon. You all can be seated. So how was lunch? Super. Anyone go to American Deli? Uh-oh. Oh, well. Okay. Good luck. No, that's really one of the few options that's nearby. So I always make that hilarious joke. But they take care of folks. There used to be a cafeteria-ish space across the street in the government center, and that went away. And there used to be something more than vending machines here, and that went away. And that's really not real helpful for folks who are stuck down here without lunch. So you did a good job foraging. There is a full-blown cafeteria, lots and lots of options in a government building right up the street. It's on Washington Street. I think that's what it's called, Washington Street. Oh, you told them about that. Great. That's a good place to go. And it's reachable. I mean, it's going to be 1,000,000 degrees this week, but you can get there and eat and be back in an hour. So if you get American Deli'd out, that's a good plan B if you don't bring your own stuff. Thank you for being back on time. Your wayward colleague, number 6, did show up. She watched a little bit of the trial from back there, but because she wasn't here for everything, she can't be serving as a juror. So we're going to go with you all as our jurors. We're still in the midst of the state's presentation. I'm going to ask Mr. Trepanier to call his next witness.
The state calls Vasquez.
Raise your hand. You swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. You go ahead and have a seat. State, explain your name for the record.
Can you state your name and spell your last name for the record?
Al Vasquez, Vazquez.
Do you mind sitting a little closer to the microphone so folks can hear you? Thank you.
All right, good afternoon, Mr. Vasquez. Hi. So what sort of industry are you employed in?
I've been in the staffing industry for 16 years.
Okay. And what sort of staffing do you currently do?
Right now, I'm in the hospitality staffing, which is helping hotels staff their departments.
Okay. And just in case anybody doesn't know, can you explain the staffing process? So how do you fit into getting employees for other folks?
Sure. Basically, once we generate the account, we'll sit down with the department managers at the different departments at the hotel. Basically, we'll gather information of what needs they have, whether in the hospitality business, we can go anywhere from administrative, front desk, hospitality department, which generally is the biggest department, laundry, and so forth. And once they determine their needs, we will definitely speak with our recruiters in our office and basically recruit for the departments.
Prior to being in the hospitality industry doing staffing, were you in, what industry were you in 2019?
It was staffing as well, but it was a different type of service. It was the staffing with the reserves network, which I worked from 13 to 19.
Okay.
It was more of a warehouse type of work.
So you worked for the reserves network?
Correct.
Okay. And that was a staffing agency?
Correct.
Okay.
It's a national company.
And what was your role with them in 2019?
In 2019, I was an account on-site supervisor at one particular company. It was a pretty good size account. So we basically, my job was just to staff that particular account.
And what particular account was that?
Saddle Creek Corporation. They're a very large warehouse.
And you were the on-site supervisor?
Correct.
So what does that mean when it comes to staffing?
Basically in charge of all departments in the property. And basically just get there early in the morning and make sure that all workers are on site, the ones that are scheduled. At that particular property, it was around, it would vary it from 55 to 65 employees. So it took me a pretty good amount, probably about an hour and a half to go through all the departments, make sure they were there. If there weren't, then basically just make sure that I try to reach out to them and see what's going on. Maybe they had a flat tire, maybe had some personal issues, they couldn't make it to work. But my job was to make sure that, you know, you contact them and see if they're coming in.
Okay. When you contacted individuals, did you make a record of that?
Correct.
And was that record, recorded in some way?
Yes, basically due to the fact that there's so many people in that particular property, we are expected to make sure that we document in our computer files, make sure that you jot down what transpired. So normally what we'll do is at the end of the day, we'll just jot it down on a notebook, and at the end of the day, just put all the information in.
Okay. I'm showing you what I previously marked as State's Exhibit 93.
Thanks.
Do you recognize State's Exhibit 93?
Yes.
Okay. What is State's Exhibit 93?
I'm sorry?
What is that?
Basically, this looks like documentation from the software that we had back then. It's called Aviante. Pretty much a lot of the staffing companies use it, and it's just for documentation.
Okay.
Input.
And is that documentation that you made?
Correct.
Okay. And does that appear to be a fair and accurate representation of documentation you would have made back in 2019?
Correct.
All right. Your Honor,
short and to the point.
Your Honor, at this time, the state would tender State's Exhibit 93 into evidence.
Ms. Feely, any objection to State's 93?
No.
Mr. Francis? Admitted.
Permission to publish?
Yes, sir.
All right, so I'm looking at page 1 of State's Exhibit 93. Can you describe sort of what is in this record and what is being documented there?
Basically, the candidate or the individual was supposed to come in. Sorry, I'm in the staffing business. I use candidate a lot. The individual was supposed to come into work. He didn't come in, so I reached out to him, and the communication was that he had a family emergency, had to go to Chicago, will return on the 21st.
Okay. Oh. And then what is page 2?
The 21st?
Yes.
Basically reached out to him again, having some personal issues, and had to leave to Chicago.
Okay. And when you say him, who are you referring to?
Individual employee, Ramel Williams. That's documented here.
Okay. And he was an employee at Saddle Creek?
Correct.
Okay. And then I want to go to the document that says date of January 22nd of 19.
Okay.
All right. What does that document indicate?
Obviously, he was supposed to return the 21st, so he didn't. So I reached out, and he's still in Chicago. And then I will close the assignment until he returns. He was in good standing. He just seemed to have some issues at home or, in Chicago. So what we do is we just close the assignment and hopefully the individual will return.
Okay. But so he could have returned to work for Saddle Creek and TRN staffing on the 21st or the 22nd.
Correct.
Okay. And then let's go to the documentation for the 29th.
Okay.
What does that indicate?
Basically, looks like I reached out and no contact. Therefore, once, we can get a hold of them, we just, our job is to make sure that the client has enough workers to get the operation rolling. So once there's no contact, we'll consider that job abandonment and we'll just replace.
Okay.
So we end the assignment.
And how long do you generally give somebody before you terminate them?
Usually 2 to 3 days.
So in this case, you held it open for more than 2 to 3 days?
Yes.
No further questions, Judge, subject to redirect.
Is Feely questions for Mr. Vasquez?
So if I'm understanding these records correctly, on January 16th, you called Mr. Williams.
I spoke with him.
So this was a phone call though?
Correct.
So he answered his phone?
Well, no, I spoke with him. I don't know if I called him or he called me.
Okay, fair enough. So he may have contacted, he might have reached out to you. Okay, but at some point on the 16th, you spoke with him.
Correct, made contact.
And he told you that he had a situation in Chicago? And he didn't tell you any details?
No, I don't.
And then on January 21st, again, either he called you or you called him, but you spoke with him on the 21st.
Correct.
And he again mentions the personal issues and leaving to go to Chicago, right?
I'm sorry?
He mentions personal issues at home.
Correct.
And again, mentions Chicago.
Correct.
And then again on January 22nd of 2019, action type discussion, either he called you or you called him, but somehow you spoke with Ramel Williams on the 22nd as well, right?
Correct.
And he said he was still in Chicago. Is that right?
Right.
Thank you.
Thank you. Is in you're done?
Yes. thank you.
Okay. Mr. Francis, any questions for Mr. Vasquez? Any redirect?
No redirect, Your Honor.
Questions from jurors? None. Okay. Thank you, Mr. Vasquez.
Okay.
You are free to go. You can leave those papers right there.
Okay.
Great. Appreciate it. Next witness.
The state calls Charles Schiffbauer.
What you said, can you raise your hand? You swear affirm that the testimony you will give the truth, the whole truth, and nothing but the truth of God. You can go ahead and have a seat. Make sure you speak into the mic. How you can spell your name for the record?
Charles T. Schiffbauer, Charles, middle initial T, last name SCHIFFBAUER.
Good afternoon. What's your title? So I address you correctly.
Police officer.
Okay. So good afternoon, Officer Schiffbauer. Where are you currently employed?
The Video Integration Center.
And what is the Video Integration Center affiliated with?
Police Department.
Is that the Atlanta Police Department?
Yes.
Okay. How long have you been employed there?
Probably 10 and a half years.
Okay. What are your roles and responsibilities at the VIC Center?
We monitor the cameras that are set out throughout the city and the license plate readers. Officers will call us for accidents to see if we can get the accident on video or not. Detectives will call us for information and see if there's any video to be looked up or tag readers to look at.
Okay. So you provide video and license plate readers to detectives and officers who need it?
Yes.
Okay. What is the Video Integration Center? Like, what is it?
It's well, it's set up. We have a video wall and two other cameras around it. That's mainly for monitoring like road races, any protest. Also monitor for protesters, or anything like that in the city, parades.
What is a VIC camera?
Some of them are single cameras. Some of them are called quad cameras, where they have 4 separate cameras that are fixed, and one that's PTZ that pan, tilts, and zooms, lets you zoom in and move it around.
Okay. Are these VIC cameras located throughout the Atlanta area?
Yes.
How many are there?
The city probably owns about 11,000.
11,000?
Yeah. The rest of them are like apartment complexes, other places that let us view their cameras.
Okay. And you mentioned apartment complex cameras and things like that. Are they integrated with the Atlanta Police Department Video Integration Center?
Yes.
Okay. Is there a VIC camera at the corner of Donald Lee Hallowell Parkway Northwest and Northside Drive Northwest?
Yeah.
Okay. Are the VIC cameras both live video and recorded?
Yes.
Okay. How long is VIC camera footage stored for?
14 days.
Okay. If an incident happens, are you able to pull footage for an investigator to review?
Yes.
Okay. When you gather footage, who instructs you to pull the area or time of footage that you need to pull?
Either the investigator that contacts us, or we also get calls for service where we can see calls coming in and we can look for cameras if they're in that area for officers on the street.
On January 14th of 2019, were you working at the VIC Center?
Yes.
Okay. And on that date, were the VIC cameras working properly?
Yes.
Was the recording system working properly?
Yes.
On that date, did you receive a description of a possible suspect vehicle that could have been involved in the homicide?
Yes.
Do you remember what that description may have been?
It was a small gray SUV with a spare tire on the back of it.
Okay. Were you able to locate a suspect vehicle that matched that description you were given around the time of the homicide?
Yes.
All right. And were you able to pull recordings of VIC cameras for that location?
Yes.
All right. Did you then, once you pass that along to an investigator or someone like that?
Yes.
Okay. Showing you what I've marked. Estates Exhibit 47. Do you recognize that?
Yes.
All right. How do you recognize what that is?
The disc with the video footage on it for Detective Ben.
Okay.
Could you say that again, please?
It's a CD, it's a DVD with the video footage of the suspect vehicle on DVD.
Did you prepare that for a particular detective?
Yes, Detective Benton.
And prior today, did you have a chance to review that?
Yes.
All right. And did you initial that?
Yes.
All right. And is that a fair and accurate recording of the Vic camera at the intersection of Donald Lee Hollowell and Northside Drive Northwest from January 14th, 2019?
Yes.
All right. You're at this time, the state tenders States Exhibit 47.
Ms. Feely, any objection to States 47?
No, Your Honor.
Mr. Francis? Admitted.
When you see a suspect vehicle on a Vic camera, so say you identify a vehicle, are you able to get further information from that vehicle from license plate readers?
Yes.
Okay. What is a license plate reader?
It's like a camera, but it takes snapshots of every vehicle license plate that rides by it. And if that vehicle is flagged as stolen or wanted in a crime or whatever, it'll alert us. If we're looking for a tag or some suspect vehicle involved in the crime, we can pull up that camera at whatever location it is and see if it hits the license plate reader, and if it's correct, a correct match, it'll tell us what kind of car it is and who it belongs to.
Okay. Are there license plate readers located where Vic cameras are located?
Yes.
All right. Is the license plate reader data stored?
Yes.
All right. How long is that data stored for?
For a year, 1 year.
1 year. On January 14th of 2019, were you able to utilize the LPR readers?
Yes.
And were the LPR readers functional?
Yeah.
All right. Were those license plate readers able to determine the license plate number of the suspect vehicle that you identified on the Vic camera?
Yes.
All right. Showing opposing counsel was been marked as States Exhibit 46. You recognize States Exhibit 46?
Yes.
All right, so what is States Exhibit 46?
Snapshots of the license plate reader of a suspect vehicle captured by the license plate reader cameras.
Is this a fair and accurate description of the license plate reader reads that you generated in this case?
Yes.
Your Honor, at this time, the state would tender States Exhibit 46.
Ms. Feely, any objection?
No, Your Honor.
Mr. Francis? No. Also admitted.
Were those license plate readers able to determine the license plate number of the suspect vehicle?
Yes.
And what was the license plate number that you located for the suspect vehicle?
Charlie Adder Robert 8996.
So for some of us who don't do the military thing, can you just spell it out?
CIR 8996.
And once you have a license plate number, can you run it through your system to generate additional locations where the vehicle passed a license plate reader?
Yeah.
All right. Did you do that in this case?
Yes,
All right.
for 1 day.
For 1 day? Does the LPR system generate, and is this, does it generate a printout when you do that?
Yes, you can have it do that.
That's I didn't catch that.
You can have it print. Yeah, you can have it print out.
Officer Schiffbauer, can you move a little closer to the microphone?
Okay.
Thank you.
Is States Exhibit 46 that generated printout in this case?
Yes.
Okay. Did you also pass that along to Detective Benton?
Yes.
On a readout, what sort of information is contained there?
Gives you a snapshot of the vehicle, the snapshot of the plate, and the information of the location and the date and time.
In State's Exhibit 46, did the suspect vehicle go through the intersection of Donnelly Hallowell Parkway and Northside Drive Northwest?
Yeah,
Okay. What time did that occur?
3:42
And is that AM or PM?
AM.
Beyond your generating of this LPR report and gathering the Vic camera footage, did you do anything else in this case?
No.
Just one moment. Right, Your Honor, at this time, the state's going to publish State's Exhibit 46.
Is this 46 or 47?
I apologize, Your Honor, this is 47.
Okay.
So we're looking at, this is the State's Exhibit, publishing it from 3:29 AM and 23 seconds. Is this the view from the Vic camera at Donnelly Hallowell Parkway and Northside Drive?
Yes.
Okay. Do you know which direction this camera is facing?
I think it's north.
Okay.
On Donnelly.
Okay. So would you see the individual here? Are they then walking south on Northside Drive?
I believe it'd be, yes.
Okay. So they're walking south on Northside Drive. So this camera would then be facing east.
Yes.
Okay. On Donnelly Hallowell. And it appears that there is an individual in this with a backpack. Is that correct?
Yes.
And the timestamp on this is approximately 3:29 AM and 24 seconds.
Yes.
All right. So we're going to go to 3:31 and 31 seconds. Yep. That vehicle making the U-turn there, does that appear to be the suspect vehicle?
Yes.
All right. Now we're going to go to 3:39 and 33 seconds. Go back a little bit more. They have written the wrong timestamp. It's like at 3:37 and it looks like 11 seconds. Does that appear to be the suspect vehicle passing north through the North Side Drive and Donnelly Hallowell intersection?
Yes.
We're gonna go to 3:42 and 30 seconds. And does this appear to be the suspect vehicle traveling west on Donnelly Hallowell Parkway?
Yes.
And is that the time that the license plate reader captured its license plate?
Yes.
No further questions, subject to redirect.
Okay. Ms. Feely, do you have any questions for Officer Schiffbauer?
I do, thank you. You were not asked to look for any other vehicles related to this case, right?
No.
And you were not asked to look for any other tags.
No.
And you're calling it the suspect vehicle because that's what was told to you, right?
Yes, it was described to me.
And all of the cars that pass by the tag reader reads the tag.
Yeah.
Okay. So not only a suspect vehicle, but potential witnesses could be gotten the tag, and what you described as then getting the owner of the car.
Yeah.
Thank you. And I want to make sure I got this right. The tag reader saves for a year. Is that right?
Yeah.
Thank you.
Mr. Francis?
No question.
Any redirect?
No, Your Honor.
Any questions from the jurors? Okay, Officer Schiffbauer, thank you for your time. You're free to go. You can leave those papers right there. You're welcome. Next witness.
His direct call is Brian Wiley.
You swear upon that testimony you give is the truth, the whole truth, and nothing but the truth of God. Thank you. Swear your name for the record.
Brian Wiley.
Mr. Wiley, can you bend the microphone up a little bit? You're taller than the last witness. Great, thank you.
And I didn't catch if you spelled your last name for the record purposes.
BRIAN WILEY. Oh.
Mr. Wiley, where are you currently employed?
Greyhound.
Are you a bus driver?
Yes.
All right. How long have you been doing that?
Almost 6 years.
So my math is right. In 2019, you would have been a bus driver.
2018.
2018. But in 2019, on January 14th, 2019, you were a bus driver at that point.
Correct.
All right. And is there, was that day different than your normal day?
For a little bit, yeah.
A little bit. So what, were you doing anything special at about 3:30 in the morning on January 14th, 2019?
On my way to work.
On your way to work. And on your way to work, do you drive on Northside Drive Northwest?
I do.
Okay. When you were driving, did you drive on Northside Drive Northwest on January 14th of 2019?
I did.
And did you see anything out of the ordinary when you were doing that?
Seen two people scuffling in front of a vehicle.
Do you remember what the people looked like?
One had long hair, one had short hair. At first, I thought it was a man and a woman scuffling. So I went down a little bit and made a U-turn.
Okay. So you see a man and woman scuffling, what you think is a man and a woman scuffling in front of a vehicle. And what sort of vehicle were they scuffling in front of?
It looked like a small SUV, a Isuzu Trooper or something to that make and model.
It's a small SUV. How would you describe that? Like, what sort of features does that sort of
It
vehicle
looked like
have?
it was square.
Square? Does it have anything like sticking out of it anywhere, anything like that?
No.
Okay. Does a trooper or a vehicle like that have a spare tire on the back?
Most of them would, but that one didn't.
That one didn't? So on that date, you see two people scuffling in front of a vehicle, and you said you slowed down?
Correct.
Okay. And as you slow down, what do? Are you looking? Are you paying attention? Or
Made a U-turn.
Okay.
Going back towards the vehicle.
All right.
And as I was going back towards the vehicle, I heard a couple gunshots. So I slowed down. And I seen one person from the front of the car run to the back of the car. And I guess he seen me coming, so he was trying to wave me to go by. That's when I made another U-turn.
Okay.
Went back towards Donald Lee Hollowell Parkway.
All right. Did you get a good look at the person who was waving you by?
Not a clear view, it was 3:30 in the morning, but figure-wise, I could tell he had a short haircut and slim, kind of tallish.
And then you said he proceeded towards, on Northside Drive, towards Donald Lee Hollowell Parkway?
Did a U-turn going back towards,
Okay. So at that point, is there a vehicle behind you at all?
Now, as I stop at the light, getting ready to make a left turn, I seen a vehicle approaching me from behind.
Okay. And then do you look in the vehicle?
As the vehicle came by, I looked to the right.
Okay. How many people were in the vehicle?
I seen two figures. On the driver's side, I seen the clear view, a pretty clear view. And on the passenger side, I just seen a figure.
Okay. So I want to start with, I'm going to go back in time a little bit and just flesh this out a little bit more. So you're driving up and you see there's a vehicle and two people at you said the front bumper?
Right.
All right. Can you describe to me how they're fighting?
Like they was tussling, not tussling as in wrestling each other, not tussling as in fighting each other, but look like trying to get something away from one another.
Okay. So for example, may I approach?
Yes.
Approach you? Okay. So if it's you and I tussling, if you, with standing up, help you demonstrate?
Yes.
So if it's you and I, we're tussling. Were we like tussling like this? Okay, so kind of show me.
Tussling like this.
Okay, so like we're grabbing at something down here. All right. And so they're doing that. One has long hair and one has just normal hair. Short. Okay.
Did you see what they were tussling over?
Not exactly, not in the beginning, but as I made a U-turn and heard two gunshots, I imagine they were scuffling for a gun.
So you heard 2 gunshots. You said you imagine they were scuffling for a gun.
I knew they were scuffling for something, and it wasn't not like, a bag or some shoes. It looked like one was actually trying to fight for his life.
Gotcha. And you come back around, and you say you see a second individual comes around the car?
Yes, there was
Okay.
2 individuals in front, and one of the individuals from the front ran to the back of the car.
Okay. And what were they doing in the back of the car?
Squatted down.
So like how far squatted down? Like were they like this? Were they down lower?
Down lower.
Down lower? And that was me at like a half squat sort of situation. So they're squatted down and they're waving you on?
Yeah, waving me to come by the vehicle.
Okay. Did you take that? Your interpretation of that was like go by, like don't stop, or was it to stop?
No, just like come on by, don't stop.
Okay. You mentioned that you didn't think that there was a spare tire on the back of the vehicle.
I didn't see one.
Okay. Would seeing some video of the incident help refresh your recollection?
It might.
Okay. I'm going to publish for you what is State's Exhibit. State's Exhibit number 4. So do you recognize this area?
Yes.
Okay, so what road is this?
I believe it's north side.
Okay. I'm starting at 3:36 and 14 seconds. So I just saw a car in that top left-hand corner kind of do a little like maneuver. What vehicle were you driving that day?
I drive a Chevy Impala.
Okay. And I see at 3:36 and 19 seconds, a vehicle making a U-turn. Was that your vehicle?
I believe so.
Okay. And I just paused it again at 3:36 and 33 seconds. And in that top left-hand corner, there's a vehicle there. Do you recognize that vehicle?
That'd be me.
That's
be my
you.
vehicle. Yes, sir.
Okay. Hit play again. So is this you coming north on Northside Drive right there?
Yes.
Kind of halfway up the video and behind the pole right now?
Yes.
Okay. Did you see in the video the car pulling in kind of behind, backing up into that area?
I see it now. Yes.
Okay. Did you see that day?
No, I did not.
Okay. So was this the vehicle that you saw that the individuals were scuffling in front of?
Yes.
Okay. And you said that vehicle came next to you at the light at Donald Lee Hollowell Northside Drive?
Correct.
So let's pull up that. We're gonna And now I'm going to publish State's Exhibit 47. Wait a second, left this block clear. So looking at State's Exhibit 47 at 3:37 and 30 seconds, does that appear to be your vehicle at the intersection?
Yes.
Okay. And if we hit play just for a quick second, we hit pause. Is that the vehicle that you saw pass you when you looked inside?
Correct.
All right.
So you're turning towards us, Mr. Wiley. That's that white car turning towards us on the screen is your Impala?
Yes, Your Honor.
Okay.
And you'd be heading west on Donnelly Hollowell when you turn that direction.
Correct.
Okay. So this camera is facing east, you're turning west.
Correct.
All right. And then if someone were to be walking down this sidewalk by the St. Mark Baptist Church sign there, they would be headed south on Northside Drive Northwest.
Correct.
Okay. Looking at the vehicle that passed you, can you see the spare tire on that vehicle?
Not clearly, no. If it has one, not clearly, no.
Okay. But that was the vehicle that passed you.
Correct.
So I'm showing you State's Exhibit 4 again. Share. So this is at 3:34 and 58 seconds. Does that look like the vehicle that you saw the individual scuffling in front of?
Yes.
Okay. Does that vehicle have the spare tire on the back?
Now I see a spare tire on the back. Yes.
Now, after you make that, and so I'm going to skip forward again, just after going through this. You make that left-hand turn onto Donnelly Hollowell Drive. So now you're headed west. Do you just keep going that way, or what do you do after?
I turn back around and go back to the scene.
Okay. When you get back to the scene, what do you see?
I see another car had pulled up prior to me returning back to the scene. And then I seen a gentleman laying in front of the vehicle.
What did the gentleman look like?
He was heavy set with, I would say, dreads.
Was he doing anything?
He was laying on the ground talking about he needed help.
Okay. Did he say what had happened to him?
No, but from the way I look at it, I could tell he was shot.
How could you tell that?
I seen blood coming from his body, plus I seen a couple gun casings on the ground.
Did you see any sort of like book bag or anything by him?
No, sir.
How fast did you get back to the scene where this had happened?
The second time I made a U-turn, once I made that left and then made a U-turn, I would say no more than 20, 25 seconds.
Did he, the individual who you saw laying on the ground with the braids or the dreads, tell anybody how he was feeling at that point?
Said he was getting cold. He was getting cold, and I told him help was on the way. And then he also said he was having a hard time breathing.
When you drove by and did your first U-turns, how many people did you see total that you could distinctly make out?
Two.
Two, okay. Could you tell if there was anybody else in the vehicle when you drove by?
Not at the time, no.
Okay. Were you actively looking? Was it hard to see?
No, I wasn't active looking. I was trying to figure out what was going on in front of the car.
Okay. Could you tell if the person that was tussling with the heavy set guy was the passenger or the driver of the vehicle?
At the time, I couldn't tell if he was a passenger or the driver.
And the individual who you said ran from the front of the car to the back of the car and ducked down, was that one of the same people that you saw tussling in the front of the car?
Yes.
Okay. I mean, what was the lighting out there for you?
It wasn't that bright. It wasn't that dark neither, but it was, you could see a figure.
Okay. And when you say a figure, you say like shapes?
Yes.
Okay. Could you make out distinct facial features?
No, it wasn't that bright.
Did you, you mentioned you heard 2 gunshots. Did you ever see a gun?
No.
I've got to ask, why did you turn around after hearing gunshots?
I was being nosy. I'm just a nosy type of individual. That time in the morning, couldn't have been, I wouldn't believe it was something that serious. Like I said in the beginning, I thought I was a man and a woman. And then I returned after all was said and done, and I realized it was a man.
Just a moment.
So the person you saw struggling with long hair that you thought first time you rolled by might have been a female was ultimately the gentleman on the ground who was saying, "I'm cold and I have trouble breathing."
Yes, Your Honor.
No further questions for Mr. Wiley, subject to redirect.
Ms. Feely, questions for Mr. Wiley?
You're just talking about on direct that the first pass you made of this situation, you couldn't see if there was other people in the vehicle. Is that right?
Correct. My attention wasn't on anyone else in the vehicle. My attention at the time was what was going on in front of the vehicle.
And the second pass you made, you still weren't looking in the vehicle. Is that right?
I didn't really make a complete second pass. As he was waving me by, I made another U-turn and went back towards Donnelly Hollowell Parkway.
And the state showed you a video and you described on the video that moment when the car passes you. Remember that?
Yes, ma'am.
And that is the moment where you say you saw 2 figures in the car, right?
Yes, ma'am.
And it was on your right side coming
Yes.
behind you.
While she's pulling that up, I may have misunderstood. Are you saying that as you were going to execute that left onto Donnelly Hollowell, that the car, the mini SUV, rolled by you? I thought you were both stopped for a minute at the light.
I was stopped at the light. He rolled by slowly.
Okay. But it wasn't that red light for everyone. You're looking, they're looking. He rolled by, but you're saying roll by slowly.
Yeah.
Okay. Thank you.
No.
And you talked with Detective Benton about this case. Do you remember that?
Yes, ma'am.
I know it's been a long time ago, so if you don't remember, just let us know. But at that time, you told her that you made a left and came back to the scene, right?
Yes, ma'am.
And when you got back to the scene, the car was still sitting there.
There was another car there. That car had left.
So in the 20 to 25 seconds that it took you to turn around, another car pulled up.
Yes, ma'am. He was laying in the middle of the street. So the car stopped for him.
All right. And do you remember telling Detective Benton that you hopped out and said, "I've seen the whole thing"?
Yes, ma'am.
And you described the person to Detective Benton, just as you did today, as a slim person
Correct.
with a thin, long face.
Correct.
So in the video that we watched a few moments ago, you say you were stopped and then the car came by you. Is that right?
Yep. I was making the left turn. My light was red. His light was green. My light was red. And he slowly passed towards me. He had his window down. I looked his way. He looked mine. I got 10 on my window, so he couldn't see me, but I could see him.
You could see him, you say?
Yeah. Better than I seen him earlier.
That's all I have at this time, Your Honor. Now that we have. I just want to play this video back for you one more time, because if I'm understanding you correctly, this is the time when you saw the two figures in the car.
Correct.
Okay. Thank you. That's all I have, Your Honor. Thank you.
All right, Mr. Francis, questions for Mr. Wiley?
Good afternoon, Mr. Wiley.
Good afternoon.
My name is Dennis Francis, and I know you've done this a bunch of times.
No, I haven't done it a bunch of times.
I get it, because I think you testified at the preliminary hearing, is that correct?
No,
Did you?
what do you mean?
But I get a chance to ask you a few questions. My questions are pretty much, I just want to make sure I have you correct. As you're driving on your way to work, you see two individuals tussling in front of a car.
Correct.
Can you orient me, if this podium is the car, to the distance that they are from the car? I'll start
Right in front of the car.
directly in front of the car.
Right in front of the car.
Almost like they could reach out and touch.
Correct.
Okay. All right. So they're tussling down here. And if I understand you correct, you believe you saw two individuals and two individuals only.
Correct.
Okay. The entire time.
In front of the car.
From the car. And then I believe you testified in response to the DA that the person you saw, one of the persons you saw tussling was the person who ran to the back of the car and waved you around. Is that correct?
Waved me to come by.
Right, but that person was one of the two people tussling.
Yeah, ran to the back of the car, yeah.
So if I have you correct, I've got a car here. I've got two people tussling, okay? Then soon after that, you turn around and you hear gunshots, is that correct?
Correct.
So I got a car, tussle, right? Then you come back around and one of the two persons from there is now at the back of the car, is that correct?
Correct.
Waving you around.
Waving me to come by. I wasn't waving me around. Come by.
Okay.
As in, come on by.
Okay.
Okay.
Well, I told you I had to be quick.
Okay.
Thank you. I had any further questions.
You're welcome.
Mr. Wiley, I'm assuming from what you were saying that the person who got to the back of the car and waved you by was not the person with long hair who you thought might have been a female.
It wasn't him.
It was the short-haired person.
Correct.
Okay. All right. Did you have any redirect?
At the time that you were doing the U-turns by the vehicle, were you able to see inside that gray SUV at all?
Not at the time, no.
No further questions.
Anything else, Ms. Feely? Jurors, questions for Mr. Wiley? Nope. Okay. Thank you, sir. Appreciate your time.
You have a good day.
You too. Next witness.
United States calls Alicia Laflour.
Yeah.
Oh, I'm sorry. Yes, ma'am. Sure. Can we stop Ms. Laflour? We're going to take a super short break. Don't apologize. When you need to take a break, take a break. Those of you who want to, are we good just letting a few jurors leave the room? Yes?
No objection.
Okay. All right. So if you need to use the restroom, we'll take an afternoon break. It's going to be in about a half hour. I'm not saying you need to wait for a half hour. So you go do what you need to do. If anyone else does, you can go with that jury. You don't have to run. Don't worry. I promise we won't go anywhere. Otherwise, folks can just sort of be at ease. Of course, it's the one at the very end of the row.
Thank you.
You're welcome.
Okay.
I don't think we got any of the bakers on the jury. I know we had several. You're one of the bakers. Excellent. All right. You know what you're doing tonight. We had a couple juries ago, someone who owns and runs a bakery. What was he called? It had the word pimp in it, but he picked that and it actually meant like pure ingredients means perfection. But it was the cupcake pimp. He was the cupcake pimp. And he brought some in and they were perfection. That guy could make some cupcakes. Yep. All right. We've got everyone we need. Ms. Rivers will get back on the record and hopefully Ms. Laflour is right outside.
You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth of God. Lord, you have a seat. Can you state and spell your name for the record?
My name is Alicia Laflour, Elisha Lafleur.
Thank you.
Ms. Laflour, good afternoon.
Hi.
Can you tell the court who were you living with in January of 2019?
I was living with Ramel Williams and D'Anthony Tolbert.
Okay. How do you know Ramel Williams?
That's the father of my child.
All right. How old is your child that you have with Mr. Williams?
She's 4.
Sorry.
She's 4.
How did you meet Mr. Williams?
At a gas station.
Two of you met and began talking?
Yes.
All right. How long before you were in a relationship with Mr. Williams?
We were in a relationship like a month or two after.
Okay. And would you say that you would describe yourself as a boyfriend and girlfriend at that time?
Yes.
You love him?
I do.
That's the only child that you have, Mr. Williams?
With Mr. Williams, yes. But I have 2 other kids.
And what part of town were you living with Mr. Williams?
In Atlanta.
Who all was living with you?
At that time, it was me, Ramel, D'Anthony, and his girlfriend.
So we're talking about January of 2019. How long had you been with Mr. Williams at that time?
January. Going on 8 months, because I think I was 6 months pregnant around then, or 7 months pregnant.
So we could describe your relationship as, an adjective. Let's say it's good, it's bad. How would you describe it?
It was great.
It was great. All right. You know Mr. D'Anthony Tolbert as well?
Yes.
How you know him?
He was living with us in the Center Hill.
How long was it?
I want to say since we moved together.
This is ballpark, month, week.
A month.
Okay, sorry. And you didn't know him any longer period of time. That's the only time you knew him was that month.
Yes.
So in January, when this incident happened, you only know Mr. Tolbert for 3-4 weeks.
Yes.
Not very well.
Not very well.
What was your relationship like with Mr. Tolbert?
I did not like Mr. Tolbert.
Okay. Was he living with you?
He was.
All right. Okay. Now, when you refer to Mr. Tolbert, how would you refer to him? Like, what would you call him?
A stray.
Well, I guess what I mean is, did he have a nickname? Or?
D'Anthony is what,
Okay, that's what you
yeah,
call him.
that's what we call it.
All right. Did you have a vehicle during that period?
Yes, I did.
What type of car did you have?
Chevy Trucker.
All right, what would you describe it? What color?
Silver.
Silver and, all right. I'm going to show you what's been marked previously as States Exhibits 48, 49, 50, and 51. Can you like to take a look at exhibits 48 through 51 and tell us if you recognize those exhibits?
Yes.
How do you recognize them?
They're mine. That's my car.
That's your car. There's a photo of your car?
Yes.
All right. And is that a photo of your car as it looked back in January 2019?
Yes.
The images depicted in 48 through 51, are they a fair and accurate representation of what your vehicle looked like at that time?
Yes.
Your Honor, the state will move to tender into evidence States Exhibits 48, 49, 50, and 51.
Any objection to those photos, Ms. Feely?
No.
Pardon me?
Any objection?
Yeah. No, okay. Mr. Francis, those are admitted.
Commissioner Publish?
Yes, anything admitted is publishable unless you hear an objection when you try to put it up. Sure.
This is for the record Exhibit 49. And that's your gray tractor.
Yes.
I didn't realize it was that. You're welcome to publish it old school way as well. If you don't want to share it on big screen.
Okay, just trying to save a little time. Okay, so now, how many sets of keys did you have to your vehicle?
One.
One set, okay. Who kept up with that set?
I kept up with it for the most part.
All right, on that keychain, did you have any other keys besides your car key?
The house key.
Okay. And did you have a job during that period?
Yes, I did.
Where you work?
At the airport.
How many days a week would you work?
5.
And you familiar with the name Vanessa Williams?
Yes.
Who's that?
That's Ramel's sister.
All right. Did she live with you during that period? January 2019?
No,
All right. She was living in a different location?
yes.
And we're talking about that period, January 2019. Who had access to drive your vehicle?
Anybody who lived in the house with us?
All right. So tell me about that. Ramel Williams had access to drive your vehicle?
Yes,
All right. You obviously could drive your vehicle.
yes,
What about Ms. Williams, Vanessa Williams?
yes,
She could drive your vehicle.
yes,
Did she have to ask you to drive it?
yes.
What do you mean by that?
Like, if I was going to work, that was the only way she would be able to, I would have to bring it to her. In other words, like, she wasn't in the house with us. She had her own location. So in order for her to be able to get the vehicle, I would have to bring it to her. She would have to drop me at work. So that way she could be able to access the vehicle.
So anytime, and you correct me, I'm gonna ask you a question. So is it, you're saying that anytime Vanessa Williams would have had your vehicle, you would have given her the vehicle?
Correct.
And so she wouldn't have been in a position to say, pick the keys up off of the dresser or the cabinet and go just try off with your car?
No,
All right. Okay. Could Ramel do that?
yes,
Williams?
yes,
Did
good.
he have to ask you to drive a vehicle?
No,
He could just go and pick the keys up off the dresser or the, cabinet, and just go and drive if he needed to do something.
yes,
All right. Did you have a limit on when he could drive the vehicle, any particular morning or not too late? Did you have any limitations on that?
no,
All right. What about Mr. Tolbert?
I didn't want Mrs. Tolbert near anything that I owned.
Okay, because I just want to be clear. You said everybody that was in the house had access to drive the vehicle.
Right,
Were you talking about DeAnthony Tolbert?
no,
Okay, so he could not drive your car.
no,
At any point when he was there, we're talking that 3 or 4 week period, that's how he said he knew him. Did he ever drive your car during that period?
no, he did not.
What would you have done if you had found out or saw Mr. Tolbert inside your vehicle driving your car?
Probably flipped out, most likely.
Now, just so, what does flip out mean? Just so I'm clear on what you mean by it.
Go off on him or get upset.
You've been upset?
Yes,
All right. Did you ever communicate that to Mr. Williams? And was he aware that you didn't want Mr. Tolbert driving your vehicle?
no,
He was not aware of that?
no,
All right. All right. So do you recall officers coming to talk to you about the location of your vehicle on January 13, 2019? Do you recall that?
talk to me, as in take me to a precinct.
Well, let's just say, did officers ever approach you about your vehicle in 2019?
Not that I recall.
Before we get into that area, I've got a question. I thought I heard you say, Ms. Laflour, that actually 4 people lived in your place in January of 2019, you and Mr. Williams
Right.
and Mr. Tolbert. And then I hear you say, and Mr. Tolbert's girlfriend?
Yes.
What was her name?
Nicole.
Nicole. So Vanessa Williams is Mr. Williams's sister, not Mr. Tolbert's girlfriend. That's a different woman.
Different.
Nicole is Mr. Tolbert's girlfriend.
Yeah.
And could Ms. Nicole use your car?
No, because I didn't know whether or not she had her license and I didn't care to ask.
Okay. So of the 4 of you who were in that space, you and Mr. Williams were the ones you were okay with driving your car?
Correct.
Okay.
Mr. LaFleur, could you, the address or the street address where you were living at that time, you don't recall that?
I just remember it was Center Hill.
Center Hill? Okay, is number 874, does that ring a bell?
Oh, yes.
Okay, all right. You recall officers approaching you and Mr. Williams at any point during that year?
Yes,
Okay, and you recall your vehicle being seized and processed for evidence?
yes.
All right, and it also let you know why they were doing it.
At the moment, at that particular moment, no.
Okay, but at some point.
At some point they did.
All right. At any point, did you make an attempt to inform officers of what you were doing on that day, January 13, 2019?
Yes,
Okay, and in particular at 3:30 a.m. in the morning. All right, do you remember that night, that morning?
I was asleep.
Okay, do you remember around what time you went to sleep?
I want to say the night before I went to Wendy's to go get me and my child something to eat. And once I got home, we ate. Once we finished eating, I would say roughly around 8, 9, maybe 10, we went to sleep. We laid down around 8, most likely fell asleep. We don't know exactly when we fell asleep, but we know we fell asleep.
Okay. Do you recall at any point getting up that night?
In the morning to go use the bathroom, because at that time I was pregnant. So I would wake up periodically through the night. I wouldn't check my phone to see what time it is to see what time it was I went to use the bathroom, but I did go use the restroom a couple times periodically throughout the night.
Okay. And were you able to tell officers whether you recall the location of persons in your residence when you got up during those periods in the morning?
No, I recall telling them that at 6 in the morning when it was time for me to, at 5 in the morning when it was time for me to get up to go to work at 6, Ramel Williams was beside me. So I went to sleep with Ramel Williams beside me, and I woke up. When I woke up to get ready for work, he was beside me.
And you were specifically asked about the location of your vehicle at 3:30 in the morning. You recall that?
Yes.
All right. Were you able to tell officers that you could say for certain where your vehicle was during that period?
Yes.
You were?
I was able to tell them that it was parked in the same spot that I parked it the night before.
Okay. In particular, if we're talking about a block of time between 2 in the morning and 4 in the morning, can you account for that period?
No, I cannot.
Okay, so you recall telling officers that you would sleep from 2 in the morning to 4 in the morning?
I was asleep throughout the night. I periodically wake up to go use the restroom. I didn't check to see what time it was when I wake up to go use the restroom. I just wake up, go use the restroom, and go back to sleep until it's time for me to wake up at 5 in the morning to go to work.
You don't recall telling Detective Benton at a specific time you recall waking up that morning?
No, I did not.
Did you do recall speaking to Detective Benton?
Yes.
If I were to show you a copy of the report from Detective Benton's report, do you think that would refresh your recollection as to the time that you told her?
Maybe.
Maybe. Would you like to take?
I would like to take a look.
It's just look at page 9. Look at this section. Just read it to yourself.
Okay, I read it.
Okay. Having reviewed that document, do you recall informing Detective Benton what time you believe you woke up that morning?
Now that I see it on a piece of paper, yes.
Okay, what time was that?
2 and 4.
Okay. 2 being the time you believe you went to sleep?
No, 2 being the time that I woke up to go use the restroom.
Okay. And what about that 4 o'clock time? You call it that time, mentioning that time to the detectives?
Yes, waking up to go use the restroom.
Okay. Now, after the detectives came and spoke with you, did you speak with Mr. Williams about what he was doing that night?
No, I did not.
In particular, did Mr. Williams make any statements to you as to driving by that location?
He said he drove by it on my way, like on the way from dropping me at work. Like he drove that direction coming from my job. That's why they have the pictures. That's why they were able to show the pictures.
Okay. So Mr. Williams' explanation for the vehicle in the pictures was that
he drove by after dropping me off.
Okay. All right.
After dropping you off at your work, nothing to do with Mr. Williams's work. Okay. What's your work?
I was at the airport at that time.
As in Hartsfield?
Yes.
Okay.
Well, and what was the time of your shift?
My shift started at 6 in the morning, so I had to be dropped off around like 5:30.
All right, so we're talking about 3:30 in the morning around Northside Drive. Is that consistent with when he would have been taking you to work?
No,
There any reason you could, well, that's not consistent with Mr. Williams taking you to work at 3:30 in the morning?
no,
Because you work at 6?
right,
All right. When he told you that, did you question him about that?
no.
Why not?
Because to be honest, whatever he tells me, I just go with the flow of it. Like I don't really question anything. At that particular time, I was not in the position to question anything, like to be honest.
Okay. Now, tell me what happens after your car is taken and you've been approached by law enforcement the first time. What happens after that?
After that, we got taken to the integration room.
Well, in particular, did you stay in the Atlanta area after that first meeting?
We were there for a couple of days. Well, a day, because then we had a funeral to go to the next day
Where was that funeral?
in Chicago.
Were you aware that Mr. Williams was employed through a temp agency at that time?
Yes,
Okay, you were aware of the job? Temp agency.
yes,
All right. And were you aware that he had gotten an excuse from his employment to attend the funeral?
yes,
Aware of that?
yes.
All right. Did you know that he was expected to be back on the 21st?
No, I didn't. I wasn't aware that he was supposed to be back. All I knew was that the employer asked for her obituary. So we had to send the obituary off to her. And
Who
that
is
was
the,
employer.
whose funeral was it?
His aunt.
Mr. Williams's aunt?
Yes.
Okay.
So do you recall, if we're talking about the 13th of January, do you recall when, how many days after that you went to Chicago?
We went 2 days after.
2 days after.
Yes.
Okay, so that was the 14th, 13th, 14th, that would have been about the 16th, is that so? That sounds about right?
Sounds about right.
All right, so if we're at the 21st, and the funeral happened around the 16th, there's roughly about, say, 5 days in between when the funeral happened and when he was supposed to report back, say the 21st. During that period, is there any mention from him about going back to work or explaining his status with the job?
He contacted his job to let them know that we had to extend the stay because there was our transportation had got fluctuated to where we were supposed to go back the same way we came to Chicago. We were supposed to go back together from Chicago, but now we have to find our own way back from Chicago to Atlanta.
What was that?
Because his sister had left us in Chicago.
That's Ms. Vanessa?
Yes.
Did you go down, did you go and travel to Chicago with your sister?
Yes.
Mr. Williams?
Mr. Williams, yes, yeah, all of us was in the same vehicle.
And what was your transportation?
A car.
A car that you owned, a car that you rented?
A car that that I had got in my name.
Okay, was this a rental?
Not a rental. It was more so we had got it out of a dealership. So I had went to a dealership and got, because my car was seized. So I had to get a new vehicle. So I went to go to a car dealership and I got a new vehicle.
Okay. And you got a vehicle that it was your responsibility to return?
Yes.
And your testimony is that Vanessa Williams left in Chicago, left and came back to Atlanta in that vehicle.
Yes, because she said she had an emergency.
Was that something that you gave her permission to do?
No.
Was it something that you were aware of?
No.
Okay. All right. When did you actually make your way back to Atlanta?
I want to say a month or two later. A month later.
And were you with Mr. Williams at that time?
No.
Were you by yourself?
I was with my son.
At any point, did you see Mr. Tolbert?
In Chicago?
Yes.
Yes.
Where did you see him at?
It was 2 nights after we came. It was the day before the funeral. He just showed up. Don't know where he came from. I just seen him.
wasn't in the car with you when you traveled.
No, he was not.
He was in a different residence that you saw. How many days after you were finished in Chicago?
A day or two. Cause the day, all I know is the day before the funeral. The day before the funeral, I seen Mr. Tolbert on the other side of town. Cause when we arrived at Chicago, we went to his mother's house, which is on one end of Chicago. And then we ended up going to the other end of Chicago because that's where around the time frame the funeral was gonna be at. So that night we seen Mr. Tolbert.
Okay. Now, Ms. Laflour, can you tell the jury, do you recall what your phone number was during that period, January 2019?
The last four was 0733.
Okay. If I were to show you a copy of the police report, do you think that would refresh your recollection as to what that number was?
Yes.
Okay. This is page 7. Sure.
Yes.
Okay, what is that number?
It's 404-671-0733.
Did Mr. Williams also have a telephone?
Yes.
Did you know it?
Not by head.
Okay, but that's a number that you dialed before.
Yes.
That's a number that would call your phone.
Yes.
And you knew that you could contact Mr. Williams and communicate with him utilizing that phone number.
Yes.
And is that number, were you also able to provide that phone number to the detectives?
If I see it, I'll probably remember it. I don't remember it.
Okay. Would it help to show you a copy of Detective Benton's report?
Yes.
Okay, I'm gonna show you on page 8. That number so court that refreshes your recollection.
Yes.
You recognize that number?
Yes.
Whose number is that?
Ramel's.
Williams?
Yes.
Could you read that number?
404-749-6092.
Now, Mr. Laflour, can you tell the court if your phone left your residence at 3:30 in the morning, January 13th?
According to what the detective said, no.
Well,
I didn't leave anyway, so
phone anywhere?
no, I did not.
You drive your car at 3:30 in the morning on January 13th?
No, I did not.
What were you doing at 3:30 in the morning?
I was asleep.
And you can't say that you were asleep where Mr. Williams was at 3:30 in the morning.
Correct.
You can't say where DeAnthony Tolbert was at 3:30 in the morning, can you?
Correct.
Is that also because you were asleep?
Yes.
One moment, Judge. Now, Miss Laflour, I'm going to turn your attention back to that night, January 13th, 2019. Do you recall the detectives asking you if your keys were in a different place when you woke up and you went to sleep?
No, but I recall telling them that I left my keys in the kitchen.
You left them in the kitchen. When did you do that?
As soon as I got home.
All right. And when you woke up, where were they?
In the kitchen.
Do you recall telling the detectives that they were in a different location?
I don't recall telling them that.
Okay. Do you recall meeting with us last week at a Zaxby's location?
Yes.
All right, it's myself and Mr. Trapinier. You recall us coming to your location?
Yes.
All right. And I specifically asked you about that. And do you recall telling us that you left your keys on the dresser, and then when you woke up, they were in the kitchen? In the kitchen. Do you recall that?
No.
I'm sorry.
No.
Okay. But you do recall speaking with Detective Benton around that January period of 2019.
Yes,
Okay, and you did speak about location of the vehicle on that night.
yes,
You did speak about your whereabouts.
yes,
You did talk about the whereabouts of Mr. Tolbert and Mr. Williams. Is that also correct?
I wouldn't know Mr. Williams or Mr. Tolbert if I'm asleep. Their whereabouts if I'm asleep.
But that in and of itself is you talking about what you know or don't know.
Okay, yeah.
Right? So you agree with that?
Yes.
Okay. Now, so did you know what type of cell phone Mr. Williams had at that time?
iPhone?
An iPhone? Did Mr. Williams during that period do a good job of keeping up with his phone?
Yes.
Okay. Did he take it with him everywhere he went?
Yes.
To the best of your knowledge?
Yes.
Okay, okay. All right, that's all I have, Judge.
Ms. Feely, questions for Ms. Laflour?
You just said that Mr. Williams did a good job keeping up with his phone, right?
Yes.
But when you were talking about being asleep, he was also asleep in bed with you, right?
When I went to sleep, he was asleep with me. When I woke up, he was beside me.
And you mentioned you were pregnant at this time.
Yes, I was.
And you had a roughly 2-year-old, I think.
No, now I have a 4-year-old. She's 4 now.
But you have another child.
Yes,
also.
I do.
And so your son was with you?
Yes.
So the people in the home were you and Ramel and your son, right?
Correct.
And then Mr. Tolbert and his girlfriend, Nicole.
Right.
And how old was your son around this time?
4 years ago. He was 3 or 4.
And you remember telling Detective Benton that you needed to get up and go to the bathroom a lot in the night?
Yes.
You remember telling her that nothing was out of the ordinary when you woke up at 2 o'clock to go to the bathroom?
Correct.
And nothing was out of the ordinary when you woke up at 4 o'clock to go to the bathroom?
Correct.
And you got up pretty early to go to work regularly, right?
Yes.
You did so this morning as well, right?
Yes.
Now, when you first spoke with Detective Benton, that was after you got stopped in your vehicle, right? The tracker?
Yes.
And she confronted you that a homicide had occurred, right?
Right.
And at that point, you were a suspect because it was your car, right?
Right.
That was your understanding when you were speaking with her.
Right.
And again, your keys were in a common area, the kitchen. Is that right?
Yes.
Any further questions?
Okay, Mr. Francis.
Yes, thank you. Mr. Brewer, good afternoon.
Hi.
My name is Dennis Francis. I represent Mr. Tolbert. I just have a few questions for you.
Okay.
874 Center Hill Avenue. That's where you live, right?
Yes.
Okay. And you work at the airport?
Yes.
Who you work for at the airport?
I worked for, I don't remember what company it was. It was on the international side. That's all I
International side?
Yes.
Okay. So what direction did you go from 874 Center Hill Avenue to get to the airport?
I don't remember.
Okay. Would you agree that 874 Center Hill Avenue is right next to Hamilton Homes? Near
Yes.
Hamilton Homes? Hamilton Homes takes you directly to I-20, is that correct?
Yes.
Okay, and from I-20 is one exit over to 285, isn't that correct?
Yes.
So would it be safe to say that probably you went 20 to 285 to get to the airport?
It depends on what type of day it is because I do pick up Vanessa in the mornings.
Okay.
So that way she could take the car.
Okay, okay. But on a morning when you go in at 6 a.m.,
Yes, that's
where would you normally go?
to go pick up Vanessa to give her the car.
Right, so that would be which direction?
When we come out of Center Hill, we'll make a left.
Okay,
Yeah.
take you to where?
There was a house. There was a houses on the right, I don't remember.
Okay, but you, is it safe to say you wouldn't go downtown from Center Hill Avenue, Georgia Tech, to go to the airport? Is that safe to say?
To be honest, I don't remember.
And you wouldn't go to get back to Center Hill Avenue from the airport, would you agree that the most expeditious route is 285 to 20 to Hamilton Homes?
Yes, that's the route. But if I have to drop off Vanessa, once again, I have to go another route to be able to drop her off.
But the quickest route
Yes.
is going downtown in Northside Drive. Is that correct?
Yes.
Now, let me see if I understand you correctly.
Okay.
You were shown pictures of your vehicle at around 3:30 a.m. on January 19th. Is that correct?
I was shown pictures, yes.
They showed you that date?
I didn't pay attention to the date. They just asked me if this was my vehicle
Okay.
and if that was my my license plate number.
Okay. And you testified that you asked Mr. Williams, was that him driving the vehicle? And he said yes?
I don't recall saying any of that.
Okay, I wrote that in my notes, that Mr. Williams explained to you that he drove by the license plate photos after dropping you off at work. You recall saying that?
Say that again.
Okay. Mr. Fawcett asked you some questions. And and one of those questions was whether you knew that your car had showed up on the license plate.
Right.
And you indicated that you asked Mr. Williams about it, and he told you, I drove by there after I dropped you off.
Yes.
Okay.
Right.
So that was on the day in question, is that correct?
No, that was the next day after we had left
Okay.
the interrogation room with Detective Ben and all of them.
He said he drove that car past that license plate reader.
After he dropped me off at work.
Dropped you. Okay. Clears that up for me. I don't think I have any further questions for you.
Mr. Fawcett, any redirect?
No redirect, Your Honor.
Okay. Anything else, Ms. Feely? Questions from the jurors for Ms. Laflour? Thank you, sir. So here's how this works. This is our first one. The lawyers and I step outside real briefly so we can discuss the questions, whatever we received, and then we'll be right back in. You stay right here, please. Counsel? We all set? Okay, Ms. Laflour, you said something in passing when you were answering one of Mr. Fawcett's questions about not questioning what Mr. Williams tells you. I think it was an exchange about, he told you this was when he was driving back from having dropped you off. The specific context doesn't matter so much as, could you explain a little bit what you meant, if you remember that comment, that like, I don't question what Mr. Williams says. Does that ring a bell that you said something to that effect?
Say, as if like, if he's going out, I'm not gonna be like, oh, where are you going? I'm not like the nagging type of girlfriend, like to ask you where you going, what you doing, what time you coming in. If you're going somewhere, obviously you're going to take care of something or do something. So I'm not gonna question you about where it is that you're going every second of the time that you feel like you're about to go somewhere.
Got it. You don't get up in his business and maybe he didn't get up in your business.
Right. We just had an understanding that if we're going somewhere, we're going to handle something. We're going to do something productive. We're going to come back with whatever it is that we need to come back with. Not much so as to where you going, what you're doing, what time you're coming in. We weren't on that type of timing. We were freshly together. So we were just trying to get to know each other more and trust each other more so.
Got it. Thank you for that. Mr. Fawcett, any follow-up for Ms. Laflour? Ms. Feely? And Mr. Francis? Okay. Thank you, ma'am. You are free to go. Appreciate your time. Ladies and gentlemen, we are going to take our afternoon break. It'll be about 10 minutes. So I'll have Deputy Gordon check on you. I know that clock's not accurate. It's just it's not way off. It's not like it's 2 o'clock. But on that clock at around 3:32 or so, I'll have Deputy Gordon check on you to make sure you've had enough of a break. If you haven't, it's your time, and let us know that. But hopefully about 10 minutes will work. Again, feel free to spread out down the hallway if you want. And if you run low on any of the supplies in there, tell us and we will try to restock things. Don't talk about the case or engage in any outside research while you are in the jury room. We'll get you back out here for the state's next witness in about 10 minutes or so. Any logistical questions? Nope. Thank you. All right, you all can be seated. Two things. First, thank you, prosecution team, for supporting each other on the AV front. It works a little more smoothly and a little more seamlessly. Ms. Feely, you had a concern when we had a bench conference about this juror question. I don't know that it materialized, but I certainly want to give you a chance to flesh out the record as fully as you think you need to as Mr. Williams's lawyer.
Thank you, Your Honor. And out of abundance of caution, I was concerned that that question could elicit improper character evidence. So that was the only objection.
Okay, and you did lodge that. I overruled it. I think it went all right, but only time and an appellate court will tell. All right, that's how it works with juror questions. This is a drought from my experience, but they set their own cadence there. We're going to take about a 10-minute break. Anything, Mr. Trepanier, that you foresee as an issue for the rest of the afternoon?
So we have a couple witnesses, Judge, coming up that aren't going to be incredibly long and will probably get us to 4-ish, maybe 4:10, 4:15. And then my anticipation is at that point, we're going to have probably a significantly long witness. And the question would be how Your Honor would want to proceed. I do anticipate that based on the way it's proceeded today, the state's case will finish tomorrow. So probably before lunch.
Tomorrow?
Yes,
Huh. Okay, tomorrow's Wednesday.
that's right, Judge.
Okay. All right.
I was.
So that's your sales pitch to say, could we end early and not?
Going to be my suggestion, Judge, that we take two more witnesses probably, and then have a end early. Address any other business that we need to address, and break until tomorrow.
Okay, and I should rely on your estimate that you will be resting lunch or soon thereafter tomorrow. I know you don't control cross-examination, but you've got a feel for how things are flowing.
Based on the flow right now, I think that would be a pretty good estimate of where the state would be resting.
Okay. Ms. Feely, thoughts about schedule and any other issues we ought to take up before we break?
No issue, John.
Okay, and no thoughts about schedule?
I mean, if we're gonna end tomorrow, no real concerns.
Okay. Mr. Francis, any issues?
No issues, and I am in favor of breaking early today if possible.
Okay, all right. So that you can let witnesses know, if in case people are hovering out there, we'll take all your short witnesses, that's at least two, and the long witness or one of the long witnesses, whoever you have in mind, Benton, whoever it might be, can go. But we ought to be ready to go at 9 tomorrow for that testimony.
Yes, sir.
Okay, all right, I'll see you all in about 10 minutes.
Hustle. Yeah, tell him we gotta talk about that. You gotta talk about that.
What's her name? Oh my God. I saw you just. Did you get from this trial? Yeah. No, not yet. Actually, I just do not. I went to calculate and instead of 0.03, it went 0.3. And I was like, wait, that's 30%. I was like, oh, shit, I know this too. I was like, oh. That slide was a bit. God, I didn't read that one time, so it's fun. Look at me. Would you have to? Oh, it's actually not the She's charged with harassment. Setting up, so she had texted with this dude. She was basically under the influence of this 20-year-old man who was telling her what to do. She texted the dude and told him where to come, and then 4 men with guns and ski dropped him. There's no allegation that she was present for it at all. There's not even, I don't think they can even really prove that she knew what was gonna happen when he got there. And I think they took an unrealized, oh, you stop. Speaking of disgusting. Speaking of disgusting. I've been collecting it to go up there. But I will say this, I'm gonna way over the court judge. There's crossing the street and a lady and a clerk stopped me and asked me for directions or something. And she positively gushed about how beautiful my skin is. And then, so I was sitting on across the street, she was and I was like, you got a baby, what's the baby doing? I said, I love her. And they cheered for me while I crossed the street. Oh my God, I love that. It's worth that. It's really easy to for me personally. Professional enough, honestly. Yeah, that's true. Just like we are. I mean, I think it's. Do you think it'd be crazy? Or and then what is there saying? Who's the I thought the name is he a conflict or something. Yeah. Complete contrast. Crazy. Yeah, it's like maybe both. Maybe. Right. Got a Harrison. Yeah. Here. What about cancer? What about his sister? Yeah. Yeah, any connection between this project? Right. I was thinking. I never see anybody, but I don't. Yeah. Like I say. I think some people are at the conference this week. I think I'm not gonna be or. Last week I got it they're so disorganized and discombobulated, nobody ever knows what's going on in the call there. The only way to remove the whole transmission in the car, thank God it's still under warranty now, because this would have cost me like tens of thousands.
Never told somebody to shut up as much.
Oh, I know, I've been dying.
Never as much.
Hilarious. That's just crazy. It's so crazy. Yeah. Yeah, they use. Yeah. Yeah, I was thinking oh yeah. That wasn't what I heard.
Yes.
Somewhere talking about. You know what I mean? So, because like I wasn't gonna do it that way, so I think that's something we need to flesh out probably too, because I'm not trying to cause an issue. So, obviously, the group being an issue, right? I don't want to get up there and have something to talk about. Which your guy said, if he is not actually going to testify.
Right, you can't do that, even if he says he wants to testify.
Yeah, only after, right, so that's, so yeah, I'm just.
Right. Yeah. So he can't mention, she can't mention that he mentioned.
I just want to make kind of flag that issue ahead of time for us, so. And what I anticipate it would be is I'm going to probably address it the way that I said I was, and that it would be, if I bring in, wouldn't Tolbert tell you it was the other guy that stuff, so it's not directly inculpating Williams? Do you have an issue with that? Well, but, and that's, I mean, taken alone, it's not, you know, it's not, yeah, I mean, like, I think it's something we need to address prior to that, just so we're line.
So we never address that.
No, let's talk about the brute issue.
Yeah, I'm saying, that's never been brought up.
He's always thinking we used to say.
Oh, okay.
How are you?
It is.
Oh, yeah, I guess you're right. So, okay, we may have a way to deal with it. Yeah.
Maybe that's.
Maybe that's.
Right.
Status. Okay, because looking at the conviction, they don't look easily redacted in the same way that you could do this with some lawyers. So they didn't charge us. Yeah, I mean, I'm just trying to avoid stupid issues that both of us are probably going to be fine with.
So, but some of the case law seems to indicate, especially with, there's the new US Supreme Court case that came out. And it seems to indicate that if the detective puts in the other guy instead of the name.
Okay.
Yes, there might be other evidence that creates that identification of that person.
Okay.
But that by itself wouldn't do it. The issue would be though, I think the use against Mr. Williams, I think that's where the issue is. And that's where the issue, the limiting instruction aspect of it is. No. There'd be too many issues with like it. And again, I think there's a way to avoid it.
Okay. Thank you. You told me, oh.
Yeah.
So someone called from North Carolina saying when they come in, you can see them. And I said, okay, yeah, but they could, anyone on the planet could come into court and look at them. It's just, you're not supposed to have a camera on them nonstop. So it's okay. So I told Michelle to thank this person for her concern, but it's okay. All right. So are we ready for your clients?
Yes, sir.
Great, let's bring him out. He's getting them. Mr. Trepanier, anything we need to discuss before the jurors come back in?
Not before the jurors come back in, no, Your Honor.
After the jurors come back in?
There's one matter of business that I think we should address prior to leaving today.
Prior to leaving?
Yes. Prior to
With the jurors in the room?
No, not with the jurors in the room.
Okay, when we're done with your two short. Okay. Ms. Feely, anything at this time? And Mr. Francis?
No, Your Honor.
Let's bring the jurors in, please. And Mr. Francis, I got official written confirmation that housing situations will be different tonight.
Okay,
All rise, Mr. Jurors. President of the county court.
Thank you, Deputy Gordon. Everyone else can be seated. Ladies and gentlemen, scheduling update. We conferred before we started our break, which is why your break went a little bit longer because we worked through a couple things. The state's going to call 2 more witnesses today. They have been described as short witnesses. I don't think that means height, but it means duration. And then the question was, do we start a long witness who we would not finish today, or do we just start that tomorrow and maybe end a little early today? My pushback was, hey, we need to be done by Friday. Their pushback was, we, the state, think we will be resting midday tomorrow, which is a whole lot earlier than they thought because we've been real efficient. So we're going to hear from those 2 witnesses. We'll probably, we will stop after those 2 witnesses. So it may be 4:30. I don't want you to think I'm not making good use of your time because you came all the way down here today. The state is ahead of schedule. And so we'll start as close to 9 as we can tomorrow morning. We won't be waiting on juror number 6 anymore. We'll just need the 13 of you to be here on time for us to get started. But more on that later. Let's pick up where we left off, which was who's the next witness from the state?
Your Honor, Investigator Stephen O'Hare.
Investigator O'Hare. Hello, sir.
No, sir. We swear affirm that the testimony will give the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. Have a seat. State display on the record.
Can you spell your last name for the record?
Yes, sir. O''Hare. That's O'Hare.
First name, sir. First name.
Oh, yeah, it's
Stephen, Stephen.
Investigator O'Hare, could you describe, tell the court where you work?
I work with the City of Atlanta Police Department.
And what are your duties?
Specifically, I am in the fugitive unit.
And what is it that you do in the fugitive unit?
So in the fugitive unit, our responsibilities are basically to locate and apprehend violent offenders who have arrest warrants who were obtained by Atlanta police detectives.
All right. Now, were you employed in that capacity in January of 2019?
I was.
All right. At any point were you tasked with apprehending or locating persons identified as DeAnthony Tolbert and Romel Williams?
I was.
And walk us through how a fugitive agent would go about starting that task out.
So typically the way it works is, in this case, a homicide investigator will obtain arrest warrants for individuals, specifically in this case, Mr. Romel Williams and eventually DeAnthony Tolbert. At the time, I was actually assigned to the Atlanta Fugitive Unit, but I was tasked out to the U.S. Marshals Southeast Regional Fugitive Task Force. We have a collaborative, basically, we work together in order to apprehend not just fugitives that are here locally in Atlanta, but individuals that may flee to other states and sometimes other countries.
Okay. And did you do that in this case?
We did.
Okay. Were you able to actually locate the defendants, Romel Williams and DeAnthony Tolbert?
Correct, with the assistance of the U.S. Marshals.
Okay. And when you say assistance from the U.S. Marshals, is that an agency that you typically enlist to assist you with locating suspects?
Correct.
And what types of assistance can the Marshals provide for your agency?
So for us, we get technical assistance, which would be utilizing technology to assist us in locating people, the ability to be able to reach beyond the borders of North Georgia without actually physically sending somebody like me to another area of the country to actually go apprehend somebody. If we have someone that flees Atlanta, like for example, in this case, went to Chicago, we could utilize the U.S. Marshals up there. It's called the Great Lakes Regional Fugitive Task Force, mostly made up of Chicago police officers or investigators, as well as U.S. Marshals up there. And we utilize them to follow up on a lead that we had developed here in Atlanta and apprehend Mr. Williams and eventually Mr. Tolbert, although they were apprehended at the same time. At the initial time, Mr. Williams was the only one with the arrest warrant.
Okay, all right. And is it your testimony that you physically went up to Chicago to perform the task?
So prior to the apprehension, negative. The Great Lakes Regional Fugitive Task Force were the ones that actually physically went to the address that I had developed and requested that they go to. They basically conducted what we call a knock and talk styled service of the arrest warrant, where they go to the door with a team and knock on the door. They received a response from a female that was inside. And when the door opened, they immediately saw Raymond Williams. He was brought out of the apartment, taken into custody without incident, at which time they later, within the next couple of minutes, located D'Anthony Tolbert.
And in particular, Investigator O'Hare, did you physically go up to Chicago?
So I did after they were taken into custody, and they cleared for us to be able to pick them up and take them out of their state to bring them back to Georgia.
All right. And did you do that?
I did.
Okay. And as far as actually locating and performing your function with the Fugitive Task Force, the techniques that you just testified, you employed those in this case as well?
Correct.
All right. And as far as the investigation itself, is that the only role that you had in this case, is apprehending Mr. Williams and Mr. Tolbert?
That's correct.
Okay. That's all I have, Judge.
Ms. Feely, do you have questions for Investigator O'Hare?
I do, thank you. And you use the term fleeing, is that correct?
Repeat that, ma'am.
You use the term fleeing on direct.
Typically, that's what we would use, yes.
And you're aware that Raymond Williams spoke with Detective Benton, right?
And yeah, I think counselors are listening. Hearsay, this witness isn't privy to that conversation.
I'm gonna overrule that as premature, just based on the question was, did the conversation happen, as opposed to what was the conversation?
Okay, so what did you know about this case? Did you have the warrants?
I had the warrants, correct.
Okay, you had the arrest warrants, right?
Correct.
And they were taken out by Detective Benton.
That's correct.
I could just have one moment. Search warrant. Yeah. Just one moment, Your Honor. I'm trying to get a copy of that warrant.
Sure.
All right, bear with me, Detective. I'm pulling up the warrants that you were involved with serving. Is that correct? The warrants on Raymond Williams, you were tasked with getting the person who's listed in the warrants arrested on the warrants. Is that fair?
That's fair.
And so you read these warrants, presumably, right?
In 2019, yes, I'm assuming.
And other than that involvement, you don't have any other information about this case. Is that right?
I do not.
So you would not know if Mr. Williams spoke to Detective Benton.
If you spoke with, I'm sorry, I couldn't understand, I couldn't hear.
So you would not know then if Mr. Ramel Williams spoke with Detective Benton. You wouldn't know,
That is not something I remember, no.
including you wouldn't know if he spoke with her while he was in Chicago. You wouldn't know that.
I would think that I would know that, but we're talking 4 years ago. I've worked
Understood.
hundreds of cases, so
And you said he was, Ramel Williams was taken into custody without incident, right?
when the Great Lakes team went to get him, that's correct.
Thank you.
Mr. Francis, any questions for Investigator O'Hare?
No questions, John.
Any follow-up, Mr. Fawcett?
There you go.
Did you say no or yes?
No.
No, okay. Any questions from the jurors? No? Thank you, sir, for being here. Appreciate it. Short witness number 2.
Your Honor, the state calls Raymond Lozon.
You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God? I do. Good Lord, have a seat. State your name for the record.
My name is Raymond Lozon, Raymond Lauzon.
Officer Lozon, good afternoon.
Good afternoon.
Can you tell the court what you are currently employed as?
I am employed as a latent print examiner.
And what is a latent print examiner?
So a latent print examiner, we receive cases that are turned in by crime scene technicians as well as officers. We examine them to see if they are of value. If they're determined to be of value, we'll submit them into the automated fingerprint identification system, or the AFIS. We'll look at the results back that come from the AFIS, do comparisons, and then we'll write reports on our findings and testify for the courts.
How long have you done that?
I have been a latent print examiner for the past 10 years.
Okay. Can you tell the court what type of training and education you received that allows you to perform that function?
So I attained a bachelor's degree from the University of Central Florida in forensic science. In order to get that degree, I completed an internship with the Brevard County Sheriff's Office, working with their crime scene as well as their latent sections. And during my time there, I completed a research project to determine the best chemical for development of latent prints on paper products. After that, I joined the Atlanta Police Department as a crime scene technician. During my time as a crime scene technician, I was able to obtain my certification with Georgia Post as a crime scene technician for the state of Georgia. After 2 years working as a crime scene technician, I moved into latent print examination. During my time as a latent print examiner, I've been taking classes in order to further my skills in latent print examination, as well as I completed my post certification as an instructor so that I can teach the classes at the academy for our new recruits coming in. And I was also able to travel with the State Department to Nigeria in order to train the Nigerian Police Department on how to do crime scene and latent print work.
Okay. Now, you mentioned training. Is there any type of annual or biannual training that you do to keep your skill set up?
What we do is we have a proficiency test that we do ever since we were accredited as the crime lab. And we do that every year to make sure that we are proficient in our skills.
Okay. Can you tell the jury how many latent prints you've had an opportunity to examine?
I don't have an exact number. It's well over 5,000-6,000 at this time.
Okay. Have you ever been called to court to testify as an expert?
Yes, I have.
How many times?
I don't keep the exact number. It's around 15 at this time.
And when you've been called to qualify as an expert or testify an expert, how many times have you actually been qualified as an expert?
Every time I was qualified as an expert.
And would that be in the Superior Court of Georgia throughout the state of Georgia?
Superior Court in Georgia, in Fulton County, as well as juvenile court, state court, and federal court.
Okay. And when you are qualified as an expert, what are you qualified as an expert in?
Latent print examination.
Your Honor, this time the state will move to tender Officer Raymond Lauzon as an expert in latent print examinations.
Ms. Feely, do you want to examine Officer Lauzon in this field?
No, Your Honor, we have no objection to being qualified as an expert.
Mr. Francis?
No, Your Honor, no objection.
Okay, I qualify you, sir, as an expert in the field of latent print examination for purposes of this trial.
Can you tell the jury what a known print is?
So a known print is created when a person presents themselves. We would then take their print, take their hand and apply it to an inked surface and then roll it onto a piece of paper. The more common one that you're going to find now is somebody would actually take their finger and apply it to a scanner and it would read their fingerprint from there.
Now, is there any difficulty that say you would experience with certain types of surfaces versus other types of surfaces?
Well, we're probably talking about latent prints in this case. And so with latent prints, the best surface is going to be something that would be like a smooth, non-porous surface. Whereas a more difficult surface to work with would be something that is roughened or textured. It also can be affected by changes in weather, such as extreme hot and extreme cold, because latent prints are typically made up of latent print residue, which is going to be water, oil, fats, and salts that are left on your fingers.
Okay. So when we say latent print, what's the definition of a latent print?
So a latent print is a chance impression created when a person's friction-rich skin comes in contact with another surface. That chance impression is created by a transfer between that person's skin and the surface. And that transfer is made up of the latent print residue I was just describing. And it has to be developed in order to be seen. That's the main part.
And you also mentioned the APHIS system. Tell the jury what that is.
So the APHIS system is a setup that we have where we can enter information into it. Basically, we're going to take a picture or scan a fingerprint card, and we'll use that image to chart out what we call the fine details of that print. So we're looking for things like a bifurcation where a ridge flows and then splits into two, or where a ridge flows and then stops, which we call a ridge ending. Once we chart out all those information, it is then sent into the computer and it searches against all the fingerprints that are in our databases to see if there is anything that is similar. And it'll return us a list of candidates that we can then compare against.
Okay. And when you say a list of candidates, what does that mean?
The list of candidates is normally going to be about 10 candidates for the City of Atlanta system, about 10 candidates for the State of Georgia system, and typically around 20 candidates for the FBI. So that's going to be people that the system looks at and says, well, these prints may be similar, but it needs a human to actually say, yes, it is, or it is not.
Okay. And is there any particular reason why, say, a human would have to come behind that determination?
Because some data sets will look similar to the computer, but when you're looking at them in reality, they don't look anything alike. Such as a loop may have some of the same characteristics in roughly the same place, but you're looking for a whirl. And those are two completely different pattern types.
Okay. So essentially, the human eye is better to recognize patterns. Am I understanding you correctly then?
Yes, it's better for us to review it and make that determination.
Okay. Now, in particular, just a general description of what a fingerprint is.
So a fingerprint is made up of the friction-rich skin that is present on the palms of your hands and on the soles of your feet. And the fingerprint is actually the distal part of the phalange, which is the finger. So it's the tip of the finger. And that pattern area contains information that can be used to make individualizations. such as the minutia that we were talking about before with bifurcations and ridge endings. The placement of those characteristics within the print are what make it useful for identification.
And is it your experience that fingerprints change at any point? Does that happen?
They can be affected by certain things. We call fingerprints persistent in that they will regrow over time, even if they get worked away, basically. But they will regrow the same every time unless they are altered by severe injury, such as scarring when somebody cuts themselves deeply. It has to go down into the last layer of the epidermis and into the dermal layer. Or if it's affected by disease, such as one of the more common ones is eczema, which can cause the fingerprints to disappear for a time, but they will regrow again as long as there is no other changes to that skin.
Okay. And as far as distinguishing one print from another, can two persons have the same print?
In the over 100 years of research and study that we have done, we have never had two individuals with the same fingerprint.
Okay. Can you tell the jury, have you heard the term ACE-V method?
Yes.
And what is that?
So the ACE-V methodology is the methodology that we use to do examinations. The first step is what we say, the A is analysis. Analysis is when we're going to look at the latent print as it's presented, and we're going to determine whether or not it's even suitable for comparison. So in the first part, we're going to look at it, say, do we see enough information in this to even make a determination? We're going to look at 3 levels of detail. The first level is the basic ridge flow and the pattern type. The second level gets into the individual characteristics, the bifurcations, the ridge endings, any dots that may be present. And the third level gets into the individual characteristics of a single ridge. So that can get down into the pore placement, the edges of the ridges, what they look like. And all that information will go into whether or not we make a determination if it could be of value for comparison. The next step is going to be comparison. In comparison, we're going to take that latent print and we're actually going to start with the latent print and compare it to each known sample that we generate. This will typically be coming back from our APHIS searches. So that list of candidates will do a comparison for each one of those to determine if there is a potential match within that. The next is going to be an evaluation. The evaluation is going to end in one of 3 determinations. The first is going to be that it's an individualization, meaning that the information present in the latent print is also present in the known print. The second being an exclusion, meaning that the information present in the latent print is not present in the known print. And the last being an inconclusive, meaning that between the latent and the known print, there isn't enough in agreement for us to be able to make a determination. So that would be the inconclusive result. The last step is the verification phase. In verification, we're going to give our work to a second qualified examiner. That examiner is then going to look at it and see if they can disprove our findings. If they can't disprove the findings, then they're forced to say that, yes, it is the same result as what we got.
Okay. And this method that you have been testifying to, is that the same method that's used in every case?
Yes, we use that same method for every case.
Okay. And is that a widely accepted method in the scientific community?
Yes, it is.
Okay. So you talked about the list of candidates. So what happens after that system has developed a list of candidates?
So after that list of candidates is developed, we'll go into what we talked about was the comparison phase. We're going to compare that list of candidates. We have their fingerprint that the system thinks it would be a match possibly to. We're then going to look and compare each one of those candidates to see if any of them have any kind of agreement that we can further research and develop. We then, if we find a candidate that we want to look at further, we can then request a fingerprint card for that person. And then we would compare that using the actual evidence against their fingerprint card.
Okay. Now, did you do that in this case?
Yes, we did.
All right. And what type of information is contained on a fingerprint card?
Typically, it's going to contain their demographic information as well as a name and then an identifying number. Then it's going to, of course, contain their fingerprints.
Okay. And let's talk about that identifying number. What is that?
So the identifying number is different for each level of search. Within the city of Atlanta, we would call that what we say is our APD number. Within the state of Georgia, we call it the SID number, which is a SID. And then within the FBI, it's the FBI number or the UCN number. That number is assigned to a set of fingerprints, and that way we can recall who that belongs to. The reason that it's not tied to a set of demographics or a set of names is because people can change their names when they go get arrested.
Okay. All right. And so were you able to find an identifying number in this case?
Yes, we were.
And you mentioned a few, the APD number, GBI number. What was the source of the identifying information in this case?
The source was the FBI number.
Okay. And was that the first time you have seen an FBI number in this case that you've been working on?
In this case?
Yeah. Well, so the time you saw the FBI number, was that the first time you've seen one of those?
Not the first time I've seen an FBI number, but the first time I'd seen this one.
Okay. All right. Sure. And you were testifying that the FBI number was a specific number, a specific identifying number assigned to a specific set of prints.
Yes, it is.
Okay. And just generally, what would be the purpose of, say, assigning a specific number to a set of prints?
The reason that we assign that specific number to a set of prints is, like I said, so that when that person is arrested further down the line, they may have decided that they want to give a false name or anything like that. We then have it tied to their fingerprints. So when they get fingerprinted, even if they gave a false name, it's going to come back to that same set of prints from the previous.
Okay. So just so we're clear, a set of fingerprints can be entered into the FBI system through a variety of purposes. We would say that, correct?
That is correct.
Employment could be one of those as well, correct?
Employment, background checks, adoption records, anything like that.
Okay. All right. So were you able to obtain an identifying number for anyone associated with this case?
Yes, we were.
And what was that, and who was that for?
Do you have the copy of the report so I can refer to that?
If that would assist you with refreshing recollection, I could do that. And this is. All right. I'm gonna hang you with the mark, state exhibit 92.
Yes, I do recognize this.
Okay, how do you recognize that?
I prepared this.
And what is that you prepared?
This is a latent comparison letter that we prepare to report our findings.
Okay, the identifying number that you've been testifying to, is that indicated anywhere on that state's exhibit?
Yes, it is. It's under the area labeled ID number for suspects.
And is anyone associated with this case specifically referenced with that FBI number?
The number is 919.
Well, before you do that,
yeah,
just is there an individual associated with that FBI number?
Yes, there is.
Okay, all right. And were you testifying to, as far as exhibit 92, that's the actual report that you prepared?
That is correct.
Okay, Your Honor, at this time, the statement of tenor and evidence states exhibit 92.
Ms. Feely?
No objection.
Mr. Francis?
No objection.
92 is admitted.
Okay. Now, Officer Lazon, can you tell the court if there's any individual and who that individual is that is associated with that FBI number?
Okay. The individual was D'Anthony Dante Tolbert, and the number that we were able to obtain was 919-723-DH4.
Okay. Now, you've been talking about the different types of prints. Can you tell us what type of prints were reviewed in your analysis?
Yes. So we were reviewing latent prints that were collected from this vehicle. To give you a better understanding of exactly what, I would need to refer to the actual packet of latent prints. no, I meant the actual evidence. Okay, so what we have is we had 3 latent lift cards that were collected. We have 1 fingerprint, we have a palm print, and we have another palm print.
Okay, and are you able to tell the jury where card 1 was retrieved from, the sample from card 1?
Yes, the sample card 1 was retrieved from the exterior rear passenger door.
Okay, were there any other locations on the vehicle where samples were retrieved? Can you tell the jury that as well?
Yes, so card 2 was lifted from the rear view mirror on the interior. And the last card, card 3, was from the exterior front passenger door.
Okay, and did any of those samples, we're talking about cards 1, 2, and 3, from the passenger door, the rear view mirror, and the exterior front passenger door, did any of those turn out a positive hit?
Yes, we were able to identify the print that was from the exterior rear passenger door.
Okay, and can you tell the court who was associated with that print?
That print was individualized to D'Anthony Dante Tolbert.
Okay, and do you have a specific finger that print was that left that print? Does
Yes,
that indicate
it was associated with finger number 6, which is the left thumb.
Okay, now just to is there anywhere documented on that form a notation as to who the crime scene technician was?
Yes, it was processed by CST Ware.
Is it common for a crime scene technician to note who lifted it or who handled the particular print on this form? Is that customary?
Yes, it is.
And so when a print is retrieved from a location, say in this instance, can you talk about some of the methods in place to ensure that it's not tampered with, lost, or stolen?
So once the crime scene technician retrieves the print, they will actually put all their information onto the back of the card, and it'll actually have their name as well as the investigator that's in charge when they're at the scene. These are then taken and they're placed into an envelope, which will then be submitted within a folder that will be turned over to a lockbox in our office. And then once that case is taken out, it's assigned to one of us, and we will start the report, and that'll generate its own chain of custody on us.
Okay, and is that a standard operating procedure as far as how custody is maintained at the Atlanta Police Department?
Yes, it is.
Are there security measures in place to prevent unauthorized access into those locations?
Yes, we have a badge system that prevents unauthorized access.
Okay, and to the best of your knowledge, was there any tampering or foul play with the evidence in this case, and specifically the fingerprints?
Not that I'm aware of, no.
Okay, all right. And as far as your involvement in this investigation, did you have any other involvement besides the review of the prints that were submitted?
No, the only other involvement that I had was a request from the DA's office later to just compare the fingerprints from the original comparison to a later arrest.
Okay, all right. That's all I have, Judge.
Ms. Feely, questions for Mr. Lauzon?
None of the fingerprints you examined matched Ramel Williams, right?
No.
Question for Mr. Lauzon? Yeah. Mr. Francis?
No questions.
Okay. Any possible redirect after only one question collectively from the defense side? Okay. Questions from the jurors? Okay, Mr. Lauzon, thank you for being here. You can leave those items right there and you are free to go.
Thank you.
So it was just 2? No more witnesses? Is that?
That's it for today.
Got it. Okay. So ladies and gentlemen, as forecast, those witnesses didn't take too long. It is about 4:30, we're going to end for the day. I need you all to do your best to be here by 9 tomorrow. You got a sense of the flow of the shuttle. It runs pretty frequently in the morning, not so much in the middle of the day, but we're getting you here in the morning. But just remember, pulling into the lot that's 5 minutes away by shuttle at 8:55 is going to be an issue because the shuttle doesn't run every 5 minutes. Is it every 15 minutes? Yeah, so try to be in the lot no later than 8:45 if that's where you're parking. You're welcome to get here as early as I get here around 8. When do you who knows when you show up? And so you can buzz and I'll let you in. If you get here before 8, you may have to wait a little while before someone can answer that button you mashed that says McBurney on it. And I think that's it logistically. This will be your first night. As an official juror, please, 2 things, no outside research and minimize the way you interact with other people about this. People are going to be curious, what was it like? How was your day? Tell them it was super, period. That's it. Okay. And then they can say, oh, you're not credible. They can assess your credibility. But don't get into more than that. When it's over, you can vent or celebrate in any way you want. But folks are just unintentionally going to say, oh yeah, I talked to a fingerprint examiner before. Let me tell you what a latent print really is. And you know what one is based on this testimony only. And if you had questions, you'd ask them by filling out one of these cards. So no outside research. Don't talk with others about your service. I'll be quiet now and I'll see you as close to 9 as we can make it tomorrow morning. Thank you so much. All right, you all can be seated. Mr. Williams and Mr. Tolbert, given the forecast that we've received from the state, it sounds like they'll be resting tomorrow, lunch-ish. When the state rests, we take a break. Jurors have to leave the room. Your lawyers may make a motion on your behalf. Unless that motion is 100, the motion would be to enter what's called a directed verdict. In other words, take the case from the jury. There's no way a jury could find beyond a reasonable doubt that you're guilty of one or more of the crimes. If I don't grant that motion, then we continue with the defense case. And the reason why I'm telling you both this is that that'll be the point when I need to have a conversation with each of you, not at the same time, it'll be separately, you'll all be in the room, about whether you're going to testify. And you may have already told your lawyer up and down, this is exactly what I'm going to do. I'm not testifying. I am testifying. Your lawyer doesn't make that decision. You do, and it's on the record. So we have a little dialogue about that. I'm just letting you know because the dialogue is not, you know what, I need a day to think about it. It will be you telling me after we have that conversation, I am or I am not testifying. I'll talk about the consequences of either decision and all the protections you have if you choose not to testify, et cetera. But I share that with you now so that I don't get a wide-eyed look from either of you. Wait, why are you asking me this now? I thought maybe on Friday I'd decide. It's probably going to be around lunchtime tomorrow that you'll need to give me your official answer. It's fine to keep talking with your lawyer about it, but in the end, as I said, I'll ask each of you individually and not, hey, Mr. Francis, what's Mr. Tolbert want to do? Ms. Feely, how's Mr. Williams want to handle this? We'll have a one-on-one conversation with the lawyers here. Mr. Trepanier, you said there was something we should talk about at the end of the day after the jury left. We're here.
The only issue that I wanted to flag was that with respect to Bruton and Mr. Tolbert's statement, obviously in Mr. Tolbert's statement, he does identify Mr. Williams as part of that statement, which would be obviously a Bruton issue. However, there is, I believe, some of the case that you cited in your order, as well as a recent United States Supreme Court case, Samia, which seems to indicate that the usage of a testifying detective or investigator saying that I was there with another guy without directly naming that individual would be sufficient, along with a limiting instruction to not use that against, in this case, Mr. Williams. And so I wanted to flag that for the court prior to us doing anything with that tomorrow.
Okay, well, we should talk about it. We'll talk about it some now, and then I'll give everyone a chance to do a little research. We can talk about it again in the morning. Of course, I've reviewed the statement. Tell me the format in which you would attempt to share with the jury what it was Mr. Tolbert had to say when he is saying, well, and these aren't his exact words, but Mr. Williams and I were driving in the tracker, and then we stopped, and Mr. Williams said, that's the guy who robbed me. I mean, he said.
So first, when it comes to presentation, the state would not be intending to introduce the video portion of it, because a redaction there, I think, would be more problematic than the usage of, in this case, Detective Benton saying, Mr. Tolbert told me that he was in the tracker with another guy. And so that doesn't identify Mr. Williams. Obviously, there are obviously inferential issues there, but that doesn't directly implicate him or inculpate him.
Okay, so your approach would be consistent with I don't remember the name of the case right now. I'm going to get it because I'm going to need to say it into the record tomorrow morning. But that where the Georgia Supreme Court said, look, because there's other evidence that a jury could rely on to show, to conclude that Mr. Williams was that other person, and not simply a detective saying, Mr. Tolbert told me he and another guy, and we all know who the other guy is. That's not a Bruton violation. I'm doing a bad job of summarizing that case, but the case greenlighted that. And so I think initially, I obviously need to hear from lawyers from the other side, that case would authorize the approach you described. And that's your intention, is not to press play and then go whenever he's saying Williams.
And that's correct, Judge. And there has been, and part of this was the most recent United States Supreme Court case that came out at the end of June. Samia, I think, addressed it the same way and seemed to come to the same sort of conclusion that the Georgia Supreme Court did with respect to that being an issue and how to treat it.
Okay, so it'd be through Detective Benton, and she would be under strict instruction to, whenever she's recounting what Mr. Tolbert said when he is implicating another person, it would be another gentleman, another guy, whomever, but not Rommel or Mr. Williams.
That's correct.
Okay, understood. Thank you for flagging that. Ms. Feely, let's stay on that topic first, and then there may be other things you want to talk about. We can have a more full-throated legal discussion in the morning, because I want to do a little research to be more comfortable with what Mr. Trepanier has described. But as an initial response, what do you have to say about the state's proposal?
So I would need to see what exactly the redaction kind of looked like, because I don't think any witness should touch on this statement unless Mr. Tolbert testifies, and that is an issue for down the line, but I would need to see the redaction, I think.
Okay, so a couple things. I don't think there's any redaction that's happening. What I understood Mr. Trepanier to be saying is that the way the jury is going to hear about Mr. Tolbert's statement to the police is that Detective Benton would be asked a question like, well, did Mr. Tolbert tell you if he was in, we see there's a tracker, there's a Chevy tracker, there's this license plate that goes back to Ms. Laflour, that connects to Mr. Williams, there's a cell phone that connects to Mr. Williams, and then we talk to Mr. Tolbert. Did Mr. Tolbert talk about being in the tracker? Yes, he did. Did he say anything about who was in there with him? Yes, he said he was in the tracker with another guy, another person. Yes, but not a name. But that's how, so there's not a redaction in the traditional sense where there's a document and something is darkened out, or there's a transcript or an audio and it goes silent for a second. it would be a human redactor, if you will, in the form of Detective Benton saying, and that's when Mr. Tolbert said that the other guy got out of the car to deal with the guy with the black backpack. I'm making these words up, but that's sort of consistent with what she heard Mr. Tolbert say in that interview. So first, because you made 2 points, that's the kind of redacting we're talking about. So it's nothing to see. You'd be hearing Detective Benton. She's on a tightrope. If she ends up saying, oh yeah, Williams, you're up again saying, oh no, like you did when the juror said what, the witness said what she said. Oh no, and then you objected. So we'll all be listening real closely on that one. But then the second thing you said is, hey, there should be no reference to any statement he made unless he testifies. I think that's the whole point why Mr. Trepanier has flagged this. Maybe Mr. Tolbert will testify. Mr. Francis can have a tough closing argument if he doesn't, but there's no guarantee and certainly no way to compel it, which is why Mr. Trepanier has flagged this. He's going to ask Detective Benton questions about what Tolbert said, and some of those questions will be in the space of, well, did he, Tolbert, tell you about whether anyone else was in the car? And she's going to talk about it, if I rule in favor of the state, anonymously. I put air quotes around that. No names will be used, but there'll be the issue you're concerned about. Does that clear up what I'm envisioning would be happening if I rule in favor of the state's approach?
Yes, I understand.
Okay.
So our concern remains the same, but it'll depend on how witness testifies and how much we stick to the game plan.
Right. Mr. Francis, your thoughts about what we've been discussing?
You're right. I read the Supreme Court case, the US Supreme Court case. Mr. Trepanier is right. I don't agree with it, but the Supreme Court is not final because it's right. It's right because it's final. I think it clearly violates Mr. Williams' confrontational rights, because that's an added witness that he can't cross-examine. Because that's the elephant in the room. We say the other guy.
Right.
And even though there's other evidence, he still ought to be able to challenge every piece of that. So I don't agree with that, but that is a correct statement of the law, and your analysis is correct. And so I think that is the best way to handle it under the current state of the law.
Sure. Okay. I will, could you know how to spell Samia?
Yes, it's SAMIA.
Okay, SAMIA. All right, no Y in it. I'm going to read that. I'll find my case again because it's sitting in the order. I'll read that, meaning the Georgia Supreme Court case. And tomorrow morning, we'll talk more about Bruton, and anyone can perfect anything more. I mean, I think you all have been very clear about your concerns and your approach, but I'll give everyone a last chance. And Ms. Feely, you'll be in a position to do an in advance objection. You can object when we're there. You may choose not to, but you will have preserved it. I'll make clear on the record that if you object tomorrow morning after I make final my ruling on this proposal, your objection there will cover the totality of Detective Benton's testimony about what Mr. Tolbert told her. That doesn't mean you can't object again, but I know sometimes defense attorneys like the cover of, look, I've objected out of the presence of the jury. I don't want to be this bouncing no, jumping up all the time. So you'll be able to handle it any way you want on that front. Okay.
The last thing I would add is if we come to a different strategic decision tomorrow morning or prior to tomorrow morning, we'll let council know as it relates to the Bruton issue so that people aren't doing research for no reason.
So let counsel and judge know?
And judge.
Thank you. Because they don't need to rule on it?
But of course, yes, if we change strategically, make a different decision in the interim, we will obviously let everyone know.
So that we're not too blindsided. I see a scenario where you get a tech person from your office to mute some things, and that way you can just press play, or you can splice it. But otherwise, what is the other option?
More limited, did Mr. Tolbert indicate that he was there? So at that point, it's not asking about was he there alone, so that you're not running into the other guy issue.
Okay.
But obviously that.
But all that comes through Detective Benton. Okay.
Yeah.
I'm going to rule on the ability to have Detective Benton talk about the other guy anonymously. If you choose to be less aggressive than that, I don't need to rule. I mean, that's less problematic for everyone. In fact, I don't know what objection I'd sustain if you said, did Mr. Tolbert tell you he was there at the scene of the shooting? Yes, he did. I don't know, because I've already ruled on the admissibility of his statement. So it's preserved. Hey, his statement shouldn't have come in, but at trial now, there's nothing brutal in that.
Well, then we have to explore the issue of what I can go into across examination.
Yep. Yep. Okay. Well, and I thank you for flagging that. I don't think under the cases you don't like, you can go further than what the state was doing. You can't create the error and a mistrial by saying, well, hey, detective, come on, who is that other guy? Did he never tell you? You'll sit down when that happens. Okay, good. All right. I think that's it. We're done a little early today, but we seem to be on track. I now have to work on the jury charge because you are ahead of schedule. We'll figure out when we would do a charge conference, but it may be that we do that late tomorrow. And if we end early, we might end early tomorrow with witnesses, depending on what the defense wants to do after the state rests. And then we do the charge conference then. But we're in a very happy zone in terms of getting this to the jury so that they're here just this week and not next week. All right. Well, if there's nothing else, do you have close for Mr. Williams for tomorrow? Yes. And we're good with Mr. Tolbert. Excellent. Thank you, everyone. See you a little before 9 tomorrow.